Good afternoon, everybody. Nice to see a few people in 3D after so long. I'm really looking forward to it. Someone offline has mentioned that it's very sunny outside and that the pressure is on to not to go way past 6 o'clock this evening, Brussels time. So we'll get going. Hello, everybody. My name is Henry Abbott. I currently work in Directorate General for Trade in DG Competition, but previously I worked for over 6 years with the hearing officers for competition proceedings. I also worked in private practice and in the Court of Justice in Luxembourg. But there are many legal roles that I haven't done, like in-house counsel, like working in a national court. And I guess that at least some of you are in those kind of roles. So I'm looking forward to hearing your own experiences and hopefully we can get a nice rounded impression of the overall enforcement architecture of EC competition law through a sharing of experiences. Now, this afternoon's module is about procedural law. Some people claim that procedural law is even more important than substantive law. I wouldn't go that far, but I would say that procedural law is usually every bit as important as substantive law in real life. It's very intertwined with substantive law. It can influence substantive law. And in real life cases, it's often procedure that determines the outcome more than the substance. And this afternoon, what I want you to leave with is an overview of the procedure that applies in connection with the enforcement of EU competition law, not only as regards the Commission, which is the first thing that many people think of, but also national competition authorities in the European Competition Network, national courts, and the EU courts in Luxembourg. And so the idea is that whether it be reading cases and understanding the substance better because you understand the procedural context, or the next thing you have on your desk next week to deal with, hopefully by having this overview, you'll be better placed to see things in the wider context. So an overview of what we'll look at. Basically, I'll start with a session on the EU antitrust enforcement architecture. And like I mentioned, that will cover both the Commission, but also what happens in the member states. It'll cover both public and private enforcement. After the break, we'll discuss some selected aspects of procedural fairness and hopefully emphasize the importance of safeguarding fundamental rights in these competition procedures. And the third block for this afternoon will be an introduction to the competition procedure before the Commission. It'll focus on the standard procedure, but will also give you an introduction to other alternative procedures that Constantine and Alfonso will elaborate on in future sessions. So, first part, like I said, that will cover the basic treaty framework and secondary law framework. Then we'll move out of turgid references to rules a bit and look at the architecture for enforcement, which, as I said, is public and private. We'll look at how the two interact, the influence of the court in Luxembourg on private enforcement, and that we'll also look at the rules that apply to the European Commission. A bit of history is necessary at the outset to understand what today's rules have changed. So the EU, as we know it now, started off life as the EEC back in the late 50s. And the competition rules were among the first to be laid down in Regulation 17. So the 17th regulation adopted by the Council. And back then, there were only 6 member states. There was only one of those member states that had any kind of antitrust tradition to speak of, and that was Germany. And the emphasis was on creating the common market, so integrating the 6 economies economically, primarily at that stage. And there were great debates on the enforcement model that would be adopted. And it was settled on having a centralized model. And that meant that, for example, agreements between competitors that had a potential anti-competitive effect had to be notified for clearance to the European Commission. And the European Commission had an exclusive competence for clearing those kind of agreements. And at the time, given the fact that everything was so new in terms of establishing competition law, it was probably the right choice. But over time, things changed. Notably, by around 2000, the prospect of a quite a significant enlargement of the European community was in prospect. And already it was clear by that stage that the European Commission was submerged in these kind of notifications of agreements that the parties expected to be cleared somehow, either through a comfort letter or a more formal decision. That meant that the Commission's resources were being, to a large extent, wasted on stuff that wasn't really the hardcore of what competition law seeks to deter and prevent, which is cartels and abuse of dominant position. And so there was a proposal to bring forward what became Regulation 1 of 2003, and we'll discuss that quite a lot as we go through. I should also mention some changes to the case law, which we'll see, which open the door for more effective private enforcement through damages actions, and we'll also come to that. To come up to today and talk about the primary law framework that we have, that means the law that's in the treaties. I'll mention firstly the Treaty on the European Union. That's separate from the other treaty, which we'll mention in just a second. And it really has the top level basic rules. Article 6 is important. It concerns fundamental rights. It commits what has now become the European Union to acceding to the European Convention on Human Rights, which is a creature of the Council of Europe. So far, that hasn't happened because the court in Luxembourg has said that the conditions aren't there to preserve the independent, autonomous nature of the European legal system, but work is ongoing on that. Another aspect of Article 6 is it says that the Charter of Fundamental Rights of the EU is to have the same value as the EU treaty. So that is in itself primary law now, treaty law. And it also, Article 6 also refers to what before the Charter was the basis for fundamental rights protection in the EU and its predecessors, the EEC and the EC. And that is two-pronged. First, the constitutional traditions common to member states, and secondly, the European Convention on Human Rights itself. And so the court drew inspiration from these two sources in particular in laying down what were general principles of EU law. And those general principles include the right to good administration, which in a way is another way of saying the right to procedural fairness. And so then on the more substantive side, I'm sure Articles 101 and 102 need no introduction. 103 is the legal basis on which the Council, so without the Parliament, was able to adopt Regulation 1 of 2003 in particular. And 104 is now defunct. It's of no practical significance anymore. 105 gives the Commission, if you like, an overarching policy role. And that has been confirmed in the Luxembourg case law, such as Master Foods, which says that the Commission also has a role in orienting EU competition policy. So I'm getting now to Regulation 1 of 2003. This was the response to, among other things, the overload of notifications to the Commission and the prospect of a significant enlargement in the early 2000s. And it brought in a regime change. This is it here. I'm sure to this audience, it needs little introduction. Many people described it as a decentralizing measure, but I'm not sure that that really captures all the nuances. As we go through, we'll see that in certain respects, it had a centralizing effect, whereby the Commission was the first among equals, along with the national competition authorities in the public enforcement of EU competition law. And that brings me to the two limbs for the enforcement of competition law in the EU. One is public enforcement, and that involves the European Commission, along with the national competition authorities of the member states. And together they make up what we call the European Competition Network. On the other hand, you have private enforcement, and we'll see that that was given impetus by a combination of the changes in Regulation 1 of 2003 and certain rulings from the EU court in Luxembourg. And in essence, the way private parties, litigants, can enforce, can contribute to the enforcement of the competition rules in the EU is by claiming damages in particular. They can also seek injunctions, of course, and all the kind of remedies that you would have in national courts, but damages is the big thing. I'll pause here because I realize that kicking off, I didn't really get a view from the audience here and on Zoom about where you kind of come from a little bit and in what areas. Maybe we'll have a kind of show of hands. Who is in private legal practice in law firms, let's say? Okay, and on Zoom, I see many people have their cameras on. Also, many people off. Obviously, feel free to turn on to the extent you can, and feel free everyone to jump in for questions. Who is from then competition authorities? Anybody? Yes, I see one hand, two hands. Okay, can if you're able to use the microphone in Zoom, which authorities are you with? Danielle and.
Hello, everyone. Can you listen? Can you hear me?
Yes.
Perfect. I'm from Ecuador, so I'm from the Ecuadorian National Competition Authority. I'm from South America.
Excellent. Well, it's great to be able to welcome you here to Brussels virtually, and that's one of the benefits of this hybrid formula, that we can have people from near and far. Obviously, the focus this afternoon is on the EU procedures, and that's what the course is about. If we have time, I can talk also about international soft law initiatives to not quite harmonize, but to reduce friction between the different procedural solutions adopted across the world. The EU has one way of doing things, but that doesn't mean, of course, that it's the only way. Far from it. And who is it? Mark? Mark, are you with the competition authority?
Yes, I'm working for the Hungarian Competition Authority. Hello.
Hungarian, okay. Yes.
Hungarian, yes.
Hungarian. And let's see, so, and anybody working with courts, or what haven't I mentioned, in-house counsel? Let's say in-house counsel. And have we in-house counsel in the house? Yes, Itka, Katerina, very good. Yves. Ah, yes, quite a few. Okay. Yeah, so I'll crack on and talk about the situation in the member states. The rules applicable to the national competition authorities, and you'll have to bear with me a little bit if I use acronyms. It's not to be obscure, it's just for reasons of space. And my slides try to introduce the acronyms as we go through. And what I'll do with this slide is, last year when I used this slide, I had different size fonts to try to show the extent to which certain norms were more important in practice than others. And this year, when I was looking at this slide, I ended up putting all of these in the same roughly size font, except for these at the bottom, which I've touched on already. So they're on the bottom. It's the set of rules, and we'll come to how they work together later on, but they are the fundamental rights types of provisions. I've already mentioned Regulation 2001. We'll come to it. We'll also come to all of these things, but maybe now is the time to mention the procedure for references to the EU court in Luxembourg for what's called a preliminary ruling. That's on top there. And that's something that's available to national courts or tribunals in proceedings before them. If they have a real and not purely fictional, academic, hypothetical question to decide before them, they can, on the interpretation of EU law, they can refer questions to the Court of Justice in Luxembourg, and the Court of Justice in Luxembourg interprets EU law, doesn't determine the facts, and it gives a ruling which has an effect throughout the EU, but it's also a direct answer to the questions put by the national court. And armed with those answers, the national court continues in the proceedings before it, applies the interpretation given by the Court of Justice to the facts, and decides the case. I've underlined judicial in judicial dialogue there because it's clear from the case law that this kind of dialogue is not something that is available as things stand to national competition authorities. There was a big case concerning the Greek authority a number of years back, and the answer was clear. It's doesn't have a judicial nature. It's administrative, and so it didn't come within this Article 267. It wasn't the questions it put to Luxembourg weren't admissible. And that case law was reaffirmed quite recently in connection with the Spanish Competition Authority. Article 3 of Regulation 1 is an extremely important provision. It concerns the interaction of EU competition law on the one hand and the national law of member states on competition on the other. And Article 3 contains a procedural rule, a rule of substance, and a kind of carve-out The procedural rule is that when there is an effect on trade between member states, and this is probably something that you've come across in the context of Article 101 and 102, then that means that when national authorities are applying their own national competition law, they must apply, in addition, EU competition law. And then the rule of substance is that the national authorities cannot come to a conclusion that that would mean that if it were allowed under 101 or 102, then it cannot be disallowed under national competition law. So there's a very strong convergence idea in that. But there is a carve-out which in recent times has perhaps taken on additional relevance. The carve-out refers to merger control rules. Okay, that is quite obvious. It refers also to national rules on unilateral conduct. So conduct that would be of the kind to fall under Article 102 rather than 101. And member states are allowed to have stricter national rules than 100 and 102. And they are also allowed to have rules that pursue a different objective to Articles 101 and 102. Article 5 of Regulation 1 concerns the application of EU law by national competition authorities. They're empowered to apply in full Article 101. That's a big change from the previous situation, where the Commission had, as I said, the monopoly on clearing agreements notified to it on the basis of the third paragraph of 101. Now, both competition authorities and courts in the member states can apply 101 directly in full to clear things. Also, it says that the national authorities can use the full range of remedies, let's say, available to them under national law. So decisions, injunctions, interim measures, and other remedies available under national law. What they cannot do is issue a block exemption under Article 101, paragraph 3, but they are allowed in suitable cases to withdraw on a specific basis the benefit of a block exemption adopted on an EU-wide basis. And EU member state courts, well, that's quite a big area. And by the way, I ought to have mentioned earlier, after this lecture, at some stage, probably next week, Valerie will circulate a version of these slides with more text on it. So people don't need to worry unduly about taking notes furiously and so on. A lot of the cases to which I'll refer and so on will have references on the version that will be circulated next week. But going back to member state courts, they have a very important role. They hear damages actions, contractual disputes, where EU competition law can be used either offensively as a sword or defensively as a so-called shield. And Regulation 1 has a certain number of provisions that concern cooperation between the European Commission and national courts. Like, for example, the possibility for national courts to ask the European Commission for its interpretation of certain competition law issues. It's something that in practice, the national courts tend not to use so readily because they have the more powerful mechanism, I would say, of the 267 preliminary reference procedure that I mentioned earlier. Article 15 allows the European Commission to make submissions in national court proceedings as so-called friends of the court, amicus curiae in Latin. And the Commission will sometimes do that where it sees a risk of fragmentation or a risk of the coherence and the uniformity and the proper interpretation of EU competition law being under threat by the way certain national proceedings are panning out. There are also mechanisms for information exchange and so on. Maybe I'll pause here and ask, do we have any questions? Anybody on Zoom? Okay. Okay, so the basic way the EU rules don't determine everything on the national level, especially as regards procedure. National procedural rules are something very close to member state sovereignty, and there's the principle of subsidiarity in EU law, which means that the EU acts when it's appropriate at a transboundary level, but when more local action is more appropriate and effective, then subsidiarity means that the member states and the local level are in the driver's seat, let's say. That's not a legal way of describing it, but that's the nutshell of the principle of subsidiarity. And a reflection of that is the principle of national procedural autonomy. It's up to the member states in principle to decide how they want to set up their national procedural rules. But there's a but. In fact, quite a series of buts which inflect that general principle. First, it's only where there are no EU rules which actually regulate the procedural question at issue. And there are an increasing number of those rules coming into place. Secondly, there's the requirement under the Treaty of the European Union for member states to introduce, if needed, remedies, courses of action for the safeguarding of rights that are held under EU law. And those courses of action, those rights of action need to respect the principles known as effectiveness and equivalence. The principle of equivalence means that if you have a comparable national rule of procedure, then it cannot be in a materially, it cannot be applied in a materially different way when EU law is concerned compared to when national law is concerned. So to take an example, in the competition law field, there's the ECO Swiss case, which concerned the enforceability of arbitration awards. And under the national rules, it was possible for public policy reasons, ordre public reasons, to refuse to enforce an arbitration award that flew in the face of national public policy. And the ECO Swiss ruling of the Luxembourg court said that, well, if that's a possibility in the national sphere, then an arbitration award that ignores competition law also, for reasons of European public policy, should not be enforced. So that's equivalence in action in the competition law field. Effectiveness one sees a lot more often in the case law. And that concerns often things like limitation periods. Effectiveness means that it's in principle for the member states to set down their procedural rules, subject to the proviso that it's not excessively difficult or virtually impossible for individuals to protect their rights under those kind of rules. So if you had a super short limitation period after which it's too late to bring your national action, then that will fall foul of the principle of effectiveness. The charter there refers to the Charter of Fundamental Rights of the EU, and Article 51 says that that applies to the member states when they are acting within the scope of EU law. And what the scope of EU law is has been subject to controversy down the years, but it's quite clear that whenever we're in a situation where you're dealing with EU competition law rules, that's in the scope of EU law. That means that the Charter applies to the member states. There is an interesting exception, we'll come to that, but I don't think it's of huge practical significance because the same kind of rules apply through a different avenue. And we'll come shortly to case law, particularly in the context of private enforcement and damages claims, case law of the Court of Justice that really goes beyond the principle of effectiveness as I've just described it, and emphasizes the effet utile, an idea in French, the full practical effectiveness of EU rules as part of the basis for making what many would consider quite far-reaching inroads into national procedural and substantive rules in the interest of Articles 101 and 102 being fully effective. And that brings us to private enforcement of EU competition law. And I'll pause here in case anyone has questions or comments. I have a question actually, and that is whether any of you here in the room or also on Zoom at home are typically involved in these private damages claims. Obviously, I don't want you to go and divulge secrets, but just in general terms, maybe again a show of hands, who deals with this kind of stuff on a fairly regular basis? Anyone in the? Two people at the back in the room and on Zoom. One hand anyway. So it would be very interesting for me to hear perhaps comments from those of you who are involved in it or anyone else on this kind of thing, because this is not something that I've been involved with in a very long time. When I was in private practice, leniency applications were all the rage. Does everybody know about the cartel leniency program? You've covered Article 101 and that kind of thing. I'm seeing a few people nodding, and we'll get to that. So leniency was the big thing back when I was in private practice, and that was in its, I hate to say, kind of infancy. It makes me feel old, but nowadays I find the interaction of the public and private enforcement quite intriguing. The whole piece involves many different moving parts, and they all interact with each other, and we'll possibly see that as we go through. But anyway, private enforcement and the impulses from the Court of Justice, first of all. Well, the early cases, still quite recent, involved the very idea that damages actions would be available in national courts. Indeed, they had to be available in national courts. Courage and Crehan was actually a pair of cases where it was an owner of a pub in the UK, still a member of the EU at the time, who wasn't paying the rent, to put it simply. And he was sued. But in his defense, he said, well, there is a whole series of these tied houses arrangements, and taken cumulatively, they are anti-competitive, and my contract with you is anti-competitive and therefore void, and I don't have to pay you the rent, let's call it rent. And that was his defense. But he went one step further, Mr. Crehan, and he said, in fact, I'm going to sue you, because if I didn't have this contract with you, I would have been able to have had lower costs, lower rent in a different world. And so I'm going to sue you. And the court in Luxembourg said in a nutshell, yes, that has to be possible under national law. And if there are obstacles in national law to that being the case, then these have to be set aside by the national judge. And a few years later, we had Manfredi, which reiterated that same kind of line and made it all the clearer that full compensation had to be available in damages, and that national rules concerning the types of damage that would be recoverable also had to be set aside if the loss was of a foreseeable nature and called for damages. So that was really a very clear statement that private enforcement would be a thing. In parallel, there was a so-called green paper on private damages in 2006, launched by the European Commission. A green paper is a kind of early stage legislative discussion paper. They were floating the idea, and they were floating the idea at that time of United States style treble damages. So not damages that would simply put you back where you would have been if the competition law breach hadn't occurred, but damages that would be 3 times that amount in order to deter companies from breaching competition law. And that's the situation that has been in the US for a long number of years. And that has influenced the way US substantive law has developed. It's one of the explanations why there are, in certain respects, differences between US substantive law on competition and EU substantive law on competition. And in the EU context, the reaction to this green paper was quite negative. So it was a bit back to the drawing board for the Commission. They brought out their white paper. We'll come to that. That led to the damages directive. But at that stage, the damages directive, at the stage of these 2 cases, Fleiderer and Donau Chemie, we didn't yet have the damages directive. And the issue in those cases was the extent to which a claimant for damages in national proceedings could have access to the file of the competition authority that had decided already that such and such a piece of conduct was a breach of competition law. And in Fleiderer, the court took a kind of a King Solomon type approach to it. They didn't say, oh no, you can't in general refuse access. Neither can you give access. You have to decide in each specific case, and it's up to the member state and the individual judges to weigh up, on the one hand, the interest in private enforcement, in giving access to certain materials like leniency applications and statements and self-inculpatory material that leniency applicants would have given. That would be gold dust for a private applicant, private damages applicant. But on the other hand, there is the public enforcement interest in keeping the incentives for leniency programs such that it's still in the interest of cartel participants to bring the cartel down by being the first or among the first to disclose the cartel to public enforcement and authorities. So there is this tension between making public enforcement strong and effective in terms of detecting cartels, and private enforcement in terms of getting reparation for losses, but also having a certain kind of deterrence effect on would-be infringers. And Dona Camille was much the same kind of thing, also access to this kind of leniency material. And also there, the result was that it's for the individual court to decide. And we'll see that fed through to the damages directive as it came out in 2014, and a big part of that is dealing with the issue of what can be disclosed and what can't be disclosed, and doing that on a harmonized basis across the EU. And then I mentioned the full effectiveness principle that one sees in almost in a specific kind of way for competition law. The court in the cases that I've mentioned there, and a few others also, has been very forthright in explaining that national procedural rules, in essence, have to give way in favor of the full practical effect of the right to damages in for breaches of EU competition law. So Cone concerned something called umbrella pricing. Is there anybody who can hazard a guess perhaps as to what umbrella pricing is? Yes.
Okay, it's on. So this is the situation when the competitor of the cartelist charge the prices which are adjusted to the level of the prices charged by the cartelists, not knowing that they are artificially inflated. So they are pricing under the umbrella of the cartel.
Yeah. I mean, that's it basically. They are adjusting their pricing to what they see in the marketplace. The key thing is, are they members of the cartel themselves? No, and that's it. So they are pricing in a market that is tainted by a cartel, brings the price of a significant portion of that market up to a certain level, and then a normal unilateral reaction to that will be to price under the cover of that umbrella, if you like. There's an element of remoteness to that, and the issue in Cone was whether the claimant would be who purchased the particular good from somebody who wasn't in the cartel, but the price that person paid was higher, or that was the claim anyway. And the issue was whether that person could have standing for this kind of loss in a national court. Is it possible to sue the members of the cartel for the price you paid for something when you bought it from somebody who wasn't in the cartel? And the court said yes, basically. The Advocate General in that case, and if anyone wants to ask about the Advocate Generals and so on, I'll be happy to explain. But the Advocate General, which advised the court before the judgment was handed down, went through a relatively detailed analysis of what the causation test in EU law should be. And the court didn't go for that kind of detail in the ruling. It simply, in essence, said, yes, in principle, it's possible to have standing for this kind of loss. Of course, you'll have to prove it. They didn't say much about how you prove causation, but they did make a reference to the foreseeability of that kind of thing, suggesting as well that in their view, that kind of loss is foreseeable, and the cartelists shouldn't be protected from being exposed to that kind of claim for damages. Otis was another case with possibly an even more exotic kind of loss. And the essence of the answer was the same. Yes, you can't rule out from the beginning that that certain types of losses just can't be recoverable, even though in the legal systems of many member states that those kind of rules exist on the remoteness of damage. And in my own jurisdiction, it would be pure economic loss, which would be a bar in other areas of law to obtaining damages for certain kind of things. But these are elements of national legal systems that, according to these cases, in principle ought to be set aside. It doesn't mean that the avenue is wide open for a damages claim to succeed. That's on the plane of theory. In practice, it's difficult to show loss, causation, etc. So I think that was partly what allowed the court to take this position of principle, and also why the court didn't get into the weeds of trying to lay down in a specific judgment procedural rules and tests for causation that would apply across the board. That's just simply judicial economy and judicial prudence. Advocate generals tend to have that greater level of freedom when they're writing, and they can say how they think things should be, but the court has to step in smaller steps, I would say. Limitation periods. So those are periods, I mentioned it before. After they expire, then a cause of action is gone because a claimant has waited too long. But when they're too short, then the effective exercise of the right to compensation for damages is affected. And cases like Cogeco and Whiteland export and import concerned limitation periods in national law in cases where the damages directive didn't yet apply. And the gist of those two cases is that the specific limitation periods there, or rules for when they start and stop, fell foul again of the full practical effectiveness, and so the national judge had to set them aside. And the final two cases I mentioned there are interesting in a wider context. They concern liability for cartel conduct, even in situations where you have had these are what's called follow-on actions. Sometimes you have follow-on actions or standalone actions. Standalone actions are when you come before a national court and you say that you think that there was a breach of competition law, but you have no prior competition authority decision to show that there has been a breach. Follow-on actions are more common in practice because they help litigants hugely by giving them strong evidence that the cartel actually did happen and that these people were found guilty of being part of that cartel. In Skanska, the issue was whether a purchaser of the assets of an undertaking that had been involved in a cartel could be held liable in national court proceedings, even when that purchaser was not mentioned in the previous competition law decision. and perhaps it could have been, but it wasn't. And the answer of the court was that a purchaser could, in that situation, be held liable, and they did that through the concept of undertaking, which you've probably already, or you will come across in the context of, well, Article 101 in particular, and commission fining decisions. SUMAL is a very recent or relatively recent decision, and it is very important also for commission fining decisions that are based on this principle of the undertaking. Basically, this is of long standing. The parent can be held liable for the activities of a subsidiary. In SUMAL, the question was whether a subsidiary, which hadn't been mentioned in the previous competition infringement decision, could be liable for the cartel behavior of the parent. So it's bottom up rather than top down. And the court said that in certain circumstances, in particular, when the subsidiary is clearly selling the same product as the parent was held liable for being in a cartel in respect of, then the subsidiary can be sued in principle and attributed the liability of the parent. So that's of relevance both in the context of private litigation, but also conceivably in the Commission's fining practice. The damages directive. I mentioned already that, well, there was the green paper, treble damages were not seen as being a good idea. And then there was a focus on full compensation for loss. And that is one of the things that comes through from the damages directive. In fact, it's clear from its Article 1 that the purpose of the damages directive is twofold. One, it's to create conditions for the successful and effective exercise of the right to compensation for cartel damage. And secondly, to regulate the interplay of private enforcement and public enforcement. And I touched on that, the whole idea of disclosure of documents. And in fact, the chapter 2 of the directive is, I've seen it described as the core of the directive. So it's Articles 5 to 8 there are quite detailed, and they show how much the Commission in particular saw it as being important that certain types of document and evidence should not be available in national proceedings. And these documents are in particular the leniency applications, which are statements where companies come to public enforcement authorities and basically hold their hands up and say, there was a cartel and we were part of it, and this is what happened, these were the meetings, dates and places and so on. And because I'm coming with this evidence to you, can I be let off the fines, please? That kind of stuff, that kind of statement that is drawn up specifically for the purposes of making a leniency application is entirely off limits under the damages directive. So contrast that with the more hands-off attitude adopted by the court, which said that it was for individual judges in individual cases. And then the bulk of the remainder of the damages directive indeed concerns this first prong of the twin objective of the directive, which is to promote the availability of damages. And Article 9, for example, talks about the evidentiary value to be given to previous public enforcement decisions. if the authority is in the same member state as you're litigating in, then it's conclusive evidence that a cartel happened, and it happened in the way described in the public enforcement decision. If the prior public enforcement decision at issue is from another member state, then it's not conclusive evidence, but it's persuasive at first sight evidence of the existence of a cartel that happened in the way it's described in the decision. Limitation periods we've already discussed, and the directive to an extent introduces a sort of minimum harmonization of limitation periods. So the court cases that I mentioned earlier, they were in situations where the directive had not yet kicked in. Article 11 contains quite detailed provisions on joint and several liability, which means that, let's say, one cartel participant is sued, it can bring in claims for contribution from the other cartel members to contribute to the damages award that would be made if the claimant is successful. That happens unless there's a kind of an exception if there's a settlement out of court, and if you settle on the steps of the court, as it were, with a claimant, then that leaves you less exposed to joint and several liability in cases that go all the way through national litigation. A question then for the audience at home and here, would anyone like to describe what passing on is in this context? Thank you.
Okay, so this is, thank you. This is the situation when the overcharge charged by the members of the cartel is passed on, is a part of the price charged by the cartel, and this inflated price is charged by the further by the customers of the customers, and it is at the end it is passed on effectively to the end customer, to the end user.
Yes. Okay. Yes. Thank you. And so the articles 12 to 15 concern this phenomenon of passing on, and it can be approached from two directions. So it can be a defense for cartelists who are sued by their direct purchasers to say, ah, well, you didn't actually suffer any loss because you have passed the overcharge on to your customers. And that's what we say, and you have to show that you didn't pass on. Equally, it could be used in an offensive way by indirect purchasers further down the chain who say, well, we didn't buy from you cartelists, but we bought from people who passed the overcharge down the chain as far as us. And so those articles introduce a form of minimum harmonization, again, of national rules concerning this phenomenon. Otherwise, you would have a patchwork of different types of national rules conceivably concerning this phenomenon, which is quite specific to cartel litigation. And you would have, anywhere where you have a mosaic of different rules, you will have an element of forum shopping, where both plaintiffs and defendants try to choose the jurisdiction and the rules that are most favorable to them. And that's also something that underlies a lot of the court case law on full effectiveness that I mentioned earlier. It comes through from the Advocate General's opinions most clearly when they say that if we had if we had different national rules on the types of damages that could be obtained in different member states, then you will have an increased phenomenon of plaintiffs going and trying to get their case before the courts of the member states where the damages rules are more favorable to them. Article 17 has a rebuttable presumption of harm, and that again ties in with the difficulty of proving actual loss in these kind of situations where evidentiary burdens are quite high, so high in fact that it's often difficult to imagine ordinary, let's say, or smaller size enterprises having the resources to run the risk of litigating this, losing and potentially facing a huge legal bill. So these kind of provisions tilt the scale a little bit in favor of damages actions being successful. I mentioned consensual disputes resolution already, and the way that it shields the settler a little bit from exposure on the basis of joint and several liability. Again, the idea is that, well, if things are settled outside of court, then that saves a lot of trouble and risk and expense on the part of claimants. And indeed, I have the feeling, but I don't know if others at home or in the room can confirm. I have the feeling that before the damages directive came into play, that there was quite a lot of out-of-court settlement in cartel matters that doesn't really get into the court reports or even the legal textbooks or the commentaries and so on. My impression is imperfect and anecdotal, but I have a feeling that in certain jurisdictions, at least, a lot of cartel claims were being brought and settled before they ever got into a courtroom. Does anyone have that impression as well, or?
At least in Germany, I have the impression that damage claims get more regular, or are being handled in front of the court more regularly. And nowadays, as it wasn't that much before, and I'm not sure. Actually, my career started after the damage directive came into play, so I don't really have the comparison. But I have the impression that before that, there were not so many claims brought in front of the courts, because it was, as you just said, very hard or the hurdles to prove a possible damage were very hard and are still very high. And this, from what I heard, actually was something that hindered lots of companies to claim for damages. And they said, okay, do we just leave it and just don't face the risk of paying the legal fees?
Yeah, that's in litigation of all kinds. That's the risk, of course, and the advice is often, but avoid an actual court proceedings if you can, because the stakes are high, and the cost of not succeeding is high as well. And then Article 22 concerns the application in time of the directive, and you would typically, that's a fairly mundane final provision in these kind of things, but there's an aspect of Article 22 that I can imagine will lead to litigation in the future as this directive is being transposed into national law. And so transposed, for those not familiar with the EU legal system, means that a directive just gives the broad brushstrokes of what should happen, but it leaves it up to the member states to decide how in their legal systems that is to be done. It's binding as to the result, but not as to the means. And Article 22 says that it says that rules of substance in this directive cannot be applied retroactively, but rules of procedure can to an extent. But it doesn't actually identify what are the rules of substance and what are the rules of procedure. And because it's left to the member states to interpret what this means, I think we can see already different solutions happening in different member states. And that is among those member states that have actually got to the stage of transposing the directive so far. It ought to have been transposed by all member states by February last year. But when I looked last night, there were a handful of member states, including my own home member state, that still had not got around to that. And I think, yeah, as I say, watch out for litigation on what this retroactive bar on substantive rules actually means. And I mentioned forum shopping before. This is quite arcane, and I don't think I'll go into detail on it. But there are two aspects. First is which countries' courts should be dealing with this, and the second is what rules should they be applying. So you might have a court in Sweden, let's say, but it might be led to apply German law. It gets quite complicated, but the relevant regulation is the grandchild of what used to be the Brussels regulation, the Brussels Convention, and the main rule there is that you sue in the country where the defendant is domiciled. But there is an exception to that for tort, delict, and quasi-delict, which competition rules fall into. And you can deviate from the domicile of the defendant and sue in the place where the harmful event occurred. But what exactly in the context of a breach of competition, of EU competition law, that means is not entirely clear. Remember that the EU competition rules kick in where there's an effect on trade between member states. So by definition, there is a multi-jurisdictional aspect of it. But the harmful, if you can show that you've been harmed in your home market and you want to sue in the courts of your home jurisdiction, then this is a possibility that you can avail of. Very fact specific though in practice. On jurisdiction clauses, there's a distinction between Article 101 and 102. If you're in a 101 situation, so a cartel, a jurisdiction clause is not necessarily going to be effective to say, well, if we're in a cartel, you can only sue us in that kind of court. That has been deemed to be not effective. But in a consumer contract setting, and if you're claiming that, for example, Apple is dominant and has breached that, then in your contract with Apple, the jurisdiction clause there, that can actually be taken account of, and that's that. The Rome II regulation concerned the second aspect that I mentioned, what actual substantive rules apply, and that's yet more complicated. The basic rule is the first bullet, and the second bullet is my attempt to condense this exception to Article 6.3. I think in practice, if you have multiple defendants across different jurisdictions, you may in fact end up applying the law of the defendant's domicile, and we've gone full circle because that happens to correspond to the jurisdictional default rule, so the defendant's domicile. Some other private enforcement issues. think we've touched on them. And perhaps well, we've just touched on quantification of damages. And I don't propose to get into detail on that. Collective redress also touches on the fact that it's difficult and risky and expensive to take a case on your own, but if you club together with other consumers or companies that claim to be harmed, then you can take joint action. That was something that was proposed to be part of the damages directive, but for some reason or other, it was dropped, and it's expressly left to the laws of the individual member states, whether that's possible or not. And we've seen a certain business model cropping up where people will gather together a group and run a case and share the proceeds of the case if they're successful, and share the pain if they lose. And interplay of private enforcement and public enforcement, I think that has hopefully come through as a theme already. In the court cases that I've mentioned, some of them you see the Commission taking a stance that is really anti-disclosure of leniency materials, pro-protection of the leniency program, and not necessarily that accommodating of the interests of private claimants in damages actions. The court and the advocates general can be contrasted a little bit with that, where they are a lot more clear about the deterrent effect of damages. The Commission emphasizes always that it's compensation, full compensation, no more, no less, and not deterrent. And that's the language of the damages directive. But the language of the case law is quite clear in saying that damages claims have an important role to play in the enforcement of EU competition rules. Now, the European Competition Network is moving over to the public enforcement side now. And I mentioned earlier that it's made up of the Commission and the national competition authorities. I've taken some of the statistics there simply to show the effect that Regulation 1 has had. Specifically, 300, no. Yes, let's look at the number of envisaged decisions notified. 129 by the European Commission, and almost 10 times as many, 1,263, by the national competition authorities. If you bear in mind that before Regulation 1 was adopted, national competition authorities hardly ever applied EU competition law, then you see a tenfold increase on that figure alone. And so by certain measures, that's a clear sign of success. It's a bit patchy, even bearing in mind the different sizes of jurisdictions. So to take the Danish example and the Irish example, they have competition authorities which are not like the Commission, which is an integrated authority. It both investigates and prosecutes and decides. In the Irish model, the competition authority investigates and then asks the Director of Public Prosecutions to take a criminal case. And it's the Director of Public Prosecutions who decides whether or not to take a criminal case. The criminal standard of proof applies. It's very high. And I think you see the result there, very low numbers. But I don't know if it's the full story, because as far as I know, the Danish competition regime has, as it's not an integrated model anyway. It's a similar sized member state, and still the numbers in Denmark are quite a bit higher. I would have liked to have caught a colleague to explore that before today, but I didn't catch her. Maybe for next time I'll get a full answer to that. So some of the applicable rules to the European Competition Network, Regulation 1, obviously, then the notice that came out at the same time, which explains the division of labor in the European Competition Network. The so-called ECN Plus directive, we'll come to it, basically boosts the powers of the competition authorities based on the experience of a number of years applying the Regulation 1 rules. And then the general principles of EU law. I mentioned them earlier. I mentioned earlier that the Charter applies when member states are enforcing EU competition law, with an interesting exception, and that's we'll come to that. The exception doesn't make a difference though, because the general principles of EU law, which as I explained, include the rights of the defense, they always have applied to the member states. And the ECN Plus directive, by saying that they apply to the member states, simply confirms the situation, restates the situation, states the obvious. And so they apply to the member states when they're applying EU competition law, and it's not Article 41 of the Charter, which applies to the EU institutions only. The European Competition Network and the rules on which it's based, both the hard law rules in Regulation 1 and the soft law provisions in the Notice on Cooperation, it amounts to a division of labor, not a division of competences. None of these rules, hard or soft, attributes jurisdiction to one or other or a number of national competition authorities. What they do is they have a mechanism for suspending or terminating cases in certain situations, notably where another authority is dealing with the case. And the Notice on Competition Rules fleshes out an agreement that was an arrangement that was struck around the time of the adoption of Regulation 1, and it has a system for allocating and, if necessary, reallocating cases among the different national authorities in the network. There are also rules on the exchange of information and notification rules, which allow this kind of allocation and reallocation to happen. And the notice contains a number of principles, and there are some examples of how they work in practice. But the idea is that a single authority, whether it be the Commission or a member state authority, should be the one who deals with a case. And there's this concept of the best placed authority, and an authority can be best placed if the conduct is chiefly in its own territory, or where it is able to award remedies which deal with the conduct in full. Sometimes maybe it isn't able to deal with the conduct in full, and then maybe the best placed authority is in a different member state. If the conduct at issue affects more than 3 member states, then in principle it's the Commission who is best placed for obvious reasons. But there's a certain feeling these days, in the last 2-3 years perhaps, that even though we've had the convergence rules in Article 3 of Regulation 1, which I mentioned, and the European Competition Network has been functioning well up up to now. There are some voices who are saying that fragmentation is creeping in. Fragmentation on the basis of this exception that I mentioned early on in Article 3, where member states are allowed to bring in stricter rules for unilateral conduct or rules that pursue different objectives from the competition law. And those voices suggest that there's a breaking down of convergence that was happening and that there's fragmentation. I think there's more than one side to that debate. What for some people is undesirable fragmentation is for others simply a laudable aspect of, if you like, rules competition. And the idea is that member states are entitled to bring, that's what Regulation 1 says. So if they can bring in stricter rules for unilateral conduct, then that's precisely what the regulation was designed to allow for. The Commission certainly does have a first among equal role in this European competition network, but it doesn't mean that it has the monopoly on wisdom on how to pursue competition policy, although it does have this orienting role. So I think that's a debate that we'll hear more of in the near future. Then the ECN Plus directive came in 2019, and it's designed to boost the powers of certain competition authorities, in particular, in terms to make sure that they have independence by being adequately resourced, by ensuring that they have adequate investigation powers. The investigation powers largely mirror the investigation powers that the European Commission has. In the context of interviews, we'll come to it later, the member states' powers are actually a bit stronger than what the Commission currently has. And it sets out provisions concerning, for example, multi-jurisdictional leniency applications and so on, which is a fiendishly complicated issue in practice and would have been, again, one of the features that deterred cartellists from applying for leniency if they felt that there wasn't a clear picture in terms of how their leniency applications in different jurisdictions would be dealt with. And that brings us to the rules applicable to the Commission. And I won't dwell on these too long. We'll have a break soon. Regulation 1, and that has an Article 33 that allows the Commission to adopt an implementing regulation. So it doesn't have to be adopted by the Council, which is the representative of the member states, but the Commission can itself adopt more detailed implementing rules, and the Commission can itself amend those, and it has done so on a couple of occasions to introduce, for example, in 2008, the cartel settlement procedure, which you'll hear more about next week. I'll touch on it at the end here. And around the time of the damages directive, the Commission also amended this Regulation 773 to align its disclosure rules for leniency materials with the rules that were applicable to national courts in the context of national litigation. There are various Commission soft law notices. A very important one for understanding Commission procedures is this notice on best practices. We'll touch on that later. The EU treaties I've mentioned, obviously 101 and 102 are the substantive law, and the fundamental rights principles, we've also covered those. maybe I'll leave you with a small sight of this, and we'll break then. And I'll ask you to. Yeah, we'll do the quiz when we come back. Let's have a break now, and we'll reconvene at 3:15, let's say. Hmm? I'm waiting to see maybe visual confirmation on the Zoom screen here in the room that people are back a little bit. I left you with quite a long glance at a slide, and the question I wanted to ask is, how many rows and columns are there in total? So rows plus columns. Can anyone even from memory hazard a guess? Or tell me how they would do it? No, I'll see. Can I get this back on again? So the slide will be coming up now anyway, and you'll get another look.
You keep pressing it and it's not working. And the square, it's not.
This one?
No, yeah, this one. And the
I
square.
think that's the.
I will call the technician.
So I've killed my slides. Now, here we are. And here is the slide. And so the question again, how many rows and columns are there in total? Just shout or put up your, people on Zoom can shout in, because I won't necessarily see a yellow hand. At this stage, you should be able to count them. Correct. Yeah. Can you tell me how you arrived at that? So for people who on Zoom, the answer in the room here was 24, which is the correct one. And Simon is going to tell me how he arrived at 24.
Because these are the official languages of the European Union.
Yes.
Okay.
Yes. And I put them up on the slide. It's a topic that doesn't really fit well anywhere, so it was just before the break. But it's to note that in the EU system, you have the principle of multilingualism. It stems from the treaty, which allowed the Council to adopt rules about languages. And the very first regulation that the Council adopted back in the late 50s was in fact on this topic. So Regulation 1, which has been amended according as member states joined with new languages that were added, that says currently that there are 24 official languages. There are many more languages in the EU, of course, than that, but the ones that are the official ones are the ones that are decided by unanimity in the Council. The Charter that I mentioned earlier also has Articles 21 and 22, which reflect the principle of multilingualism. And in competition law practice, that means that in Commission enforcement proceedings, the Commission has to respect the principle of multilingualism. And that means that defendants are entitled to have documents addressed to them in one of the official languages of their member state of domicile, for example, unless they waive their language rights. And in practice, that's something that happens quite a bit. We're all doing this in English, for example, because in this day and age, English is so prevalent, and DG competition is no different. So one sees, specifically in the context of cartel settlement proceedings, which we'll get to at the end, one of the conditions for that is that the would-be settler waives its right to its own choice of language of proceedings, and typically the language of proceedings is English. Okay, so much for that. We'll now move on to a section on the protection of fundamental rights in the EU enforcement system, both in the context of the member states and in the Commission's context. I've touched on this before, but it's a little bit convoluted the way the protection of fundamental rights became part of the EU's legal order. I mentioned right at the beginning with the picture of old white men at the table in black and white that originally it was all economic. It was about integration of the common market and so on, and fundamental rights were very much an afterthought. Literally, they weren't really part of the piece in the initial manifestation of what was then the European Economic Community. But fundamental rights came to be part of the EU law system through the what are now the general principles of EU law. So these are general principles of law, EU law, that take inspiration in particular from the constitutional traditions of the member states and the European Convention on Human Rights. The European Convention is something that the EU is legally committed to joining up to, but as yet it hasn't happened. As I mentioned, there are negotiations that, as far as I can tell, have picked up now that COVID is less of a thing in Belgium. But back in 2014, the move to accede to the European Convention of Human Rights suffered a setback when the EU's court in Luxembourg basically said that the specific details of that accession would challenge the autonomy of EU law, and they didn't give the green light to the proposed international agreement. The way the protection of fundamental rights is made more visible nowadays in the EU legal order is through the Charter being made part of primary law, and the Charter indeed having been drawn up in the 2000s, and it's the version of 2007 that has become part of the EU's treaty law makeup. And the Charter basically compiled a number of fundamental rights and freedoms. There's a distinction between them, but it's not entirely clear what is a right, what is a freedom. But the idea was to have a catalogue of rights and freedoms to make them more visible. And over time, the court in Luxembourg has become freer in referring to the Charter. It used to studiously avoid deciding rulings on the basis of Charter provisions at a time when the Charter was still not part of the treaty setup. And even after that was the case, it took the court a while to become comfortable referring to the Charter. Now it does so on a routine basis. So that right to good administration is this provision that applies to the EU institutions, but not to the member states. The reason is this little preposition here that I've underlined, by. And the case law is clear that that provision is to be interpreted literally. It can't be stretched to mean that the rights, which include those ones that are set out there, A, B, C, under Article 41, paragraph 2, they don't apply to the member states. But I explained earlier that they, in practice, do through another avenue, which is through the general principles of EU law, and that is made express in Article 3 of the ECN Plus directive. The right to good administration, it's a multifaceted kind of thing, and it's stated to include, so there are other facets to it than the ones that are expressly set out in paragraph 2 of the Charter. The important ones for our purposes are the right to be heard before something adversely affecting your legal position is adopted. That's extremely important, and we'll see its manifestations a little bit later. A corollary of the right to be heard is the right of access to the file. A corollary means it goes hand in hand with it, but it's not the right of access to file is not a freestanding right. It's not an end in itself. It's a right that exists in order to make the right to be heard more effective. And access to file in the context of commission proceedings is a major part of the reasons why they take as long as they do. It can get quite contentious, quite messy, but the case law is clear. The right to be heard means you have a right of access to the file. It wasn't always as clear as that. The courts decades ago were less demanding of the commission. And in fact, it was the commission itself which put forward soft law documents back in the 90s, I think, where it committed to greater access to file, and the courts latched on to that, and the right of access became embedded in case law as a result. And the obligation to give reasons is something that applies across the board in EU administrative law as a key feature of administrative law in the EU system. And it's there to allow both the addressees of legal acts to understand the reasons for those acts, and if necessary, to be able to challenge them. And it's also there for the EU courts to be able to exercise their powers of judicial review. And if the statement of reasons is inadequate to achieve this twofold purpose, then for that reason alone, it can affect the legality of the adopted act. Other fundamental rights that are listed in the Charter, set out in the Charter, include Article 7, the right of privacy, of the inviolability of your home and your communications. That can come into play in investigative measures, which we'll touch on later, things like inspections, requests for information, and so on. Article 48 talks about the presumption of innocence, which is, again, a fundamental feature. It leads to quite interesting constellations in the context of what are called staggered hybrid cartel settlement procedures. A bit of a mouthful. We'll touch on those at the end, but Constantine next week, I think, will be going into more detail on that. Rights of the defense gets a look in as well in Article 48. The Charter is in some respects not an entirely clear and logical set out. It's a compilation of things that were discussed and put in together in a way that leads to a certain amount of overlap sometimes. Article 49 is not a clear provision to read, but it touches on the principle of legality and the principle of proportionality. What I'd like to discuss a bit more is Article 50. And that talks about no second trial or punishment for the same criminal offense. In Latin terms, that's usually given the shorthand ne bis in idem. There's a lot of Latin in EU law because of, well, lawyers in the past at least used to like using Latin. It's gone out of fashion in the English-speaking legal world. Well, at least when I was training, it was taboo to be talking in Latin. The Americans tend to refer to the same kind of idea as double jeopardy. And double jeopardy gets the Hollywood movie, and non bis in idem, no. Non bis in idem, the sequel. But anyway, the The case law is in flux at the moment on the bis in idem, and competition law is at the heart of it, but the issues go right across EU law. And I'll get to it, but the next Tuesday, I think, there are two rulings set to be handed down in Luxembourg, which may or may not add some clarity to an area of law, which is, however way you look at it, not so clear as things stand. That sort of apparent incoherence was noted by the Advocate General in the 2012 case of Toshiba, which concerned the gas insulated switchgear cartel, and a decision by the Czech competition authority, which concerned the Czech territory and a period predating Czechia's accession to the EU. And so it was quite easy to say that, well, EU law proceedings against the gas insulated switchgear cartelists were not actually a second iteration of the Czech proceedings. They weren't being tried again for something that they had already been tried for in the past. What's possibly of more general interest about the Toshiba case is that the Advocate General pinpointed the fact that in EU competition law, you have one test for bis in idem, and in all other areas of competition law, notably the European arrest warrant, you have a different test. The competition law test is three-pronged. The identity of facts, parties and interests, legal interests, and the other test, which is a test that is favored by the European Court of Human Rights, so the one that deals with cases under the European Convention of Human Rights, which I mentioned the EU has not yet acceded to. That has a two-pronged one, which focuses on the identity of the parties and the identity either of the offence or of the facts. And also there in Strasbourg, the case law is not entirely consistent. But what the Advocate General in Toshiba proposed was that the competition law three-pronged test should be aligned to the simpler two-pronged test, which would focus on the facts. And it didn't matter if you had different legal interests protected by different rules arising out of the same set of facts. If you take, for example, there's one in the case law, the drug smuggling. That can be the unlawful drug smuggling across a border between member states. That can be the unlawful export of drugs, but also coming the other way, the unlawful import. And you can have different offenses involved in different member states, each side of the border, but the facts are entirely the same. And the issue in a different case in the EU was whether the same person could be convicted for the same drug smuggling act, set of facts, whether he could be convicted in one member state for importing them and in the other member state for exporting them. And the answer was no, because it was about the identity of facts. If you applied the competition law three-pronged test to that, the result would not be so clear, because the case law in competition law is to the effect that EU competition rules and national law competition rules pursue different objectives, and that was said as far back as the 60s, and so therefore conceivably it's possible to be convicted under both. And in fact, that's what Article 3 of Regulation 1 allows and says, remember, Article 3 obliges national member states to apply EU law when there's an effect on trade between member states, and they are applying national law. So if they're applying national law, they must in addition apply EU law. And so we'll come to a case where that happened, and we'll see what. In fact, it's this one. Sometimes I can make a fist of reading Polish, but this particular name is beyond me. And that was a situation where the Polish authority applied its national law and applied EU competition law at the same time, without any commission decision having been adopted regarding that set of facts. And the defendant there said, hold on a minute, you're applying for the same set of facts, both national law and EU law, and you're fining me for both. That is against my charter rights. It's being tried twice for the same conduct. And the answer was, no, nebis in idem doesn't apply, because there isn't a bis, and the national law and European law pursue different objectives, and Article 3 of Regulation 1 allows precisely this. So there isn't a second trial for the same set of thing. It's the same set of proceedings. You just happen to be applying EU law and national law at the same time in the same proceedings. But you do have to take account of the principle of proportionality, which means that you can't give the full whack of fines for up to 10% of annual turnover for EU law and give a similar fine on the basis of national law, because that would be doubling up and be disproportionate. And so in the ultimate amount of fines, you have to take account of the fact that you're using a double legal base with respect to the same set of facts. Slovak Telecom is another case where, again, the existence of two legal tests for nebis in idem was in discussion. What happened in Slovak Telecom was that the Slovak National Competition Authority took a margin squeeze case against Slovak Telecom in the early 2000s, closed its case, and it was appealed and knocked about in the national courts for several years. And after the administrative fine had been issued by the Slovak National Authority, the Commission also took a margin squeeze case against Slovak Telecom and issued a fine. And the issue before the court was, is this not contrary to the principle of nebis in idem, being charged afresh for something that the national authority had applied? And the court stuck to the competition law version of nebis in idem, but explained it a little bit more. And they said there's two parts to the nebis in idem. The bis, Latin for second, I suppose, refers to the fact that there's been a previous decision, and idem meaning the same. It has to be both a second decision and it has to be about the same thing. And there are three elements in considering whether something is the same. Is it the same set of facts? Is it the same offender? And is the same legal interest being protected? And in the circumstances, they suggested that it was not bis because of the fact of Article 11.6. Article 11.6 of Regulation 1 means that when the Commission opens proceedings, it relieves all the other members of the European Competition Network of their jurisdiction to pursue the case until the Commission is finished those proceedings. And it gets a little bit complicated, but what the court was suggesting is that the Slovak national decision didn't in fact concern the same set of facts, because it was about slow internet and fixed line telephony. And the Commission's margin squeeze was about broadband internet and, if you like, later forms of technology. So it wasn't the same set of facts, but that was for the national court to check. But they said that if it proved that it was in fact the same set of facts, ne bis in idem would still not apply. Why? Because once the Commission adopted or opened its proceedings on the same set of facts, it wouldn't be ne bis in idem that prevented the Slovak National Court proceedings from continuing. It would be Article 11.6 of Regulation 1. And that doesn't have an effect on national courts directly. So the National Court would still be competent to deal with the appeals that were before it of the competition law, the competition authority's decision. But the competition authority would be legally obliged to withdraw its case from before those courts. So whichever way you looked at it in Slovak Telecom, there wasn't a problem. Either ne bis in idem applied and it wasn't bis, or if it was, then you didn't get as far as ne bis in idem because by operation of law, the Slovak proceedings didn't exist anymore. It seems to be a sort of slicing and dicing solution, and it's not entirely convincing. It's logically coherent, even if I haven't explained it too coherently, I fear. But it's still a peculiar kind of situation. It puts a lot of pressure on the wording of the Commission decisions to open proceedings, because these were typically something that were very short and quite open-ended in their wording, because when the Commission is opening proceedings, it's at a relatively early stage of the case, and the Commission doesn't necessarily know what the contours of the suspected infringement are, geographically or factually. And I used to see the decisions opening proceedings, and they would be 3 lines. What the court in Slovak Telecom did to justify or to explain some of its reasoning is that a decision to open proceedings is a decision indicating the Commission's intention to proceed to adopt a certain kind of decision. And that's not quite what the Commission, not quite the way the Commission had described it in, for example, its notice on best practices, where the Commission was saying opening proceedings doesn't prejudge what we're going to do afterwards. And the court in Slovak Telecom went back to old case law that concerned Regulation 17, this original regulation that had the central notification and clearance mechanism. And we see this slicing and dicing now in other cases like this Amazon, where the Commission opened proceedings against Amazon for all of the EU except Italy. Why did they carve out Italy? Well, it was because the Italian competition authority had already opened proceedings against Amazon for what one would imagine is a similar kind of behavior. But according to the logic of Slovak Telecom, that wouldn't be a problem because the Commission opened proceedings in respect of every member state except Italy, and the bis in idem wouldn't kick in. Amazon actually challenged the Commission's decision opening proceedings against it for every country except Italy in the EU, but they were unsuccessful because a decision opening proceedings is considered to be an act that doesn't have legal effects. And so that's an example of procedure actually determining the substantive outcome of a case. And I imagine that if a decision is ultimately adopted against Amazon, they will have standing to challenge this kind of thing, and they may well call into question the idea that the Commission can carve out a member state that just happens to be investigating Amazon for the same kind of thing, and that is neither problematic according to the rules on division of labor in the European Competition Network or the principle of ne bis in idem. But we'll see in time. But next week we have rulings that are expected in these two cases, and if you want to go into the office, if you work in an office and impress colleagues, you can say, I'm very much looking forward to these rulings. Have a read over the weekend, if you have nothing better to do, of the Advocate General's opinion in both of these cases, which kind of come as a pair. Read Bipost first, and then Nodsuka. And it's a very clear and interesting exposition of why the ne bis in idem tests in EU law are inconsistent, why, in the view of the Advocate General, this is a problem, and what he proposes in as a solution to that. And as it happens, if you boil it down, what he is proposing is that the EU across the board adopts something like the three-pronged competition test rather than the two-pronged test that is influenced by the Strasbourg case law. But because that two-pronged test has recently been laid down or affirmed by the Luxembourg courts, the EU court's Grand Chamber, it's difficult to imagine that the Grand Chamber just 2 or 3 years later will completely overrule what it said so recently. So it's likely that it's going to be answered on a more narrow basis, but I still think that there will be signals there for how ne bis in idem will be interpreted, not only in competition law, but in other areas of EU law to come, conceivably. It's maybe not the end of the story next Tuesday, but it'll be another episode in it, and possibly quite an interesting one. Now we're coming to fundamental rights as they apply to the European Commission. I mentioned that the European Commission was an integrated agency. The actors in the European Commission system first. Well, you have the College of Commissioners. These are at the political level, the people who sit at the very highest table in the Commission. And underneath them, you have the civil service, composed of different departments and services, one of which is DG Competition. And DG Competition is, not just the case team, we'll come to that, but it also has a chief economist team, etc. At the head of each civil service department, you have the commissioner, a commissioner who is a member of the College of Commissioners, the group in the middle there. And it's Margrethe Vestager, the Danish commissioner, who is currently the competition commissioner. A different service, separate from DG Competition, is the legal service. And they are the litigators for the Commission. But in another respect, they're also a kind of a clearinghouse for the EU courts in Luxembourg, because it's up to them to go in and defend what the Commission comes up with. In practice, you'll usually have the effect of the legal service restraining some of the wilder flights of fancy coming from some of the DGs. And so it's not unusual to have a little bit of constructive professional tension between the different DGs and the legal service, because the legal service tends to get the reputation for being the blockers and the conservative people and so on. But they are the people who would have to stand up and defend something in court. So to that extent, they are a kind of a clearinghouse before anything actually gets to the court. The hearing officer as well, we'll come to that later. I probably won't say too much about it now. But again, the hearing officer will also sift out a lot of stuff that otherwise would be litigated in court and possibly bring a whole commission decision down. So the hearing officer is there to safeguard the effective exercise of the rights, the procedural rights of participants in proceedings. But by doing that, it makes the overall result of these proceedings less prone to legal challenge on the basis of procedural grounds. And then you have the European Competition Network, who gets in there as well, because there is such a thing as an advisory committee, and the advisory committee is made up of the competition authorities of the member states, and they are involved, as we'll see, quite late on in the procedure of adopting a commission decision, and they also give input on substance and procedure, and so they are part of the machinery for the Commission adopting a Competition Law Act. Maybe a little quiz now again. So people at home on Zoom, be at the ready to, first of all, help us identify what these pictures represent. No prize for this. This is the European Commission. But what does this picture stand for? Any guesses? Well, it's the mafia. Okay, I'll just put it bluntly like that. It's the best I could do without breaching copyright to just say the mafia. This is an This is an executioner, and copyright should be acknowledged here. But first, tell me, what does this represent? Anyone?
No one expects the Spanish Inquisition.
Nobody expects the Spanish Inquisition. No, and so yes, copyright should be acknowledged. I tried to get Mastic Men to depict the Spanish Inquisition, but it was very gruesome. The question is, which one of these is the odd one out, and why? Now, there is a right answer, the way I conceive it, but there are possibly other ways of. I mean, as long as you back your answer up, that's absolutely fine. Would anyone like to hazard a guess and simply explain why? Because it will tease out some of the issues here. Yeah.
I'm not sure if it's also what you think, but I would, from a legal perspective, think the mafia, because they are not backed up by law.
Yes, well, that's a good answer. It's not the one I have in mind, but you see, there's a way of justifying probably any of these four. But so it's not the mafia. Anyone? Any ideas? But thank you for the answer, and it does. It stacks up, I think. On Zoom, anyone?
maybe if the idea is to tackle the multiple roles that the Commission has, which have also been criticized, so they are, I guess, they have the fact-finding role, they have the executive role, and also they call the shots like the mafia. So,
Yes.
Which one would be the odd one out?
Reading the game. Yeah, the odd one out then.
They all work.
The executioner.
Maybe.
Sorry?
Maybe indeed, yeah.
Sorry, I didn't catch that. You, which one do you choose? It's not the mafia.
My suggestion was they all fit.
Oh, but well, there is an odd one out. But anyway, you've actually read the game, as I say, and that is what I am getting at. The odd one out for me is the executioner, because it's neither the judge nor the jury, whereas the mafia is judge, jury, and executioner, let's say, at least in the films I've seen. Similarly, the Spanish Inquisition. And yes, the charge that the European Commission faces is that it is in effect the judge, jury, and decision maker, finer, in the cases that it runs. That's because it's an integrated agency, which, by the way, several of actually the bulk of the national competition authorities are. So the Commission has an investigative role, a kind of prosecutorial role. It puts the charges to the undertakings concerned. It's also the decision maker. And it imposes fines, very substantial fines usually. If it doesn't impose fines, it can also impose commitments without a finding of infringement, but commitments do place obligations on the people who accept them. And as I mentioned way back, it also has an orientation role in EU competition policy, Article 105 of the TF-EU treaty. And in that context, it actually writes the rules itself. So on one look, it is kind of open to a certain criticism. And a criticism in years past, which was quite vociferous at times, was that the Commission's integrated model was incompatible with the right to a fair trial, which is enshrined in particular in Article 6 of the European Convention of Human Rights. Now, in Regulation 1, you have this provision, which, like Magritte's painting with the pipe that says it's not a pipe, says that proceedings under under this regulation are not criminal in nature. But of course, you have the Strasbourg Court for the European Convention of Human Rights, which has long-standing case law known as the Engel case law, dating back to 1976. And that concerns the definition for the purposes of the convention of what is criminal and what isn't. The importance there is that Article 6 doesn't kick in, and the Strasbourg Court doesn't have jurisdiction under Article 6 if something isn't criminal. So the criteria they developed in the Engel case, and many, many cases after that, were to define what was actually criminal in nature for the purposes of the right to the fair trial in Article 6. And the first criterion was, well, what is it labeled in the national legal system? That's one important thing, but it's not determinative. So the fact that Article 23, paragraph 5 said that commission proceedings are not criminal in nature is not determinative. You can say they're not criminal in nature, but we're going to look at other things like the nature of the offense, whether it carries a stigma. And the third prong of that criteria is the severity of the penalties. And it was at a time when the Commission's fines kind of jumped very substantially to very big figures that the voices began to be louder, saying there are problems here in terms of the right to the fair trial because the fines are high. There is the nature is quasi-criminal, carries a stigma, and what you label it as being doesn't matter. But the case law in Strasbourg also makes a distinction between what is termed the hardcore of criminal law, which is probably what Article 6 is primarily aimed at, and then stuff that is outside of the hardcore of criminal law. And for what is outside of that hardcore, the fact that you have a combination of roles at the administrative level, like you have in the Commission and like we've seen, doesn't necessarily matter as long as there is what Strasbourg Court called full judicial review afterwards. That kind of perfects the piece. And that came through in cases like Usilla in 2006, and also in connection with the Italian Competition Authority in the Menarini diagnostics case. And I'll include these cases in their fuller version of the handouts that will be distributed next week probably. And so the question moved on to being, well, whether the judicial review available in the EU system could be considered to be full judicial review as the Strasbourg Court had required. And the Court of Justice in Luxembourg was alive to the risk that the scope and intensity of the review that it had begun to apply to Commission decisions was maybe a little bit too deferential towards the expert administrative body that the Commission is considered to be. In the early days, there wasn't this mantra of deference that had kind of crept in almost by accident to say that, well, basically only manifest errors can be overturned because the Commission is the expert and they know what they're doing. And it had a place in certain kind of cases for distribution agreements and so on, but not, it sort of grew beyond its initial context. And so the court in Luxembourg began to be a bit more demanding of the Commission, and we see that to this day. And that was manifested in certain decisions that were big setbacks for the Commission, like the Air Tours case and so on. Yeah, there was a trio of cases in the early 2000s in the sphere of merger control, and that was the courts in Luxembourg sending a clear message to the Commission and to the outside world that the level of scrutiny was being stepped up a bit, perhaps. And so the prevailing view now, and you'll see cases, the court itself has decided that the level of review that it performs is adequate to meet the criteria of Usilla. And that case about the Italian Competition Authority that I mentioned, that can be quite readily transposed to the situation of the Commission. So the prevailing view now is that indeed the Commission setup of being an integrated agency is okay because the Luxembourg courts exercise an appropriate level of judicial review on Commission decisions. And in addition, at the administrative level, you have a number of increased checks and balances that have been either reinforced or introduced at the Commission level to further safeguard the effective exercise of procedural rights. And we'll go through the main ones now. State of play meetings, those of you who are in practice will probably have come across that. That's something that the Commission itself introduced, and it's not set out in any regulation or anything like that, but it is in the best practices. And we have the opportunity to have state of play meetings at certain stages in the procedure, often just before or just after particular milestones. And so that's like an informal meeting between the Commission officials, in particular the so-called case team, and the undertakings concerned, or the lawyers and advisors. We have the statement of objections, which was always there, and we'll discuss it later, but that's like a charge sheet, and that is there to delimit the contours of what is being alleged against the parties. Anything that is not in there can't form part of the basis of a fining decision unless you actually supplement the statement of objections. And we'll discuss that a bit later. If a statement of objections is sent, that triggers a right for the addressees of the statement of objections to ask for an oral hearing. We'll again discuss that later. It's not quite like an adversarial party against party hearing in a national court. People often equate a DG competition with the case team that they may see across the table from them in meetings if they're representing clients in commission proceedings. But there's more than that. You have the chief economist team, you have the private office, or what's referred to in French as the cabinet of the commissioner, the competition commissioner. You will have sometimes peer review panels where certain other colleagues not in the case team are specifically given a devil's advocate role, and so they go off and do their homework separately, and you put the case team in with the peer review panel who will pick holes in their case, and often that's something that you don't see too much in the outside world, because the Commission tends not to publicize in the individual instances of it unless there's a legal reason for it. But all of these things mean that it's not just the case team assessing a case. There are other actors still inside DG competition who are dealing with a case. You also have the legal service, and I mentioned that one of their functions is again to be a kind of clearinghouse for the court. They will often have an influence on safeguarding the proper application of the law, because it's in their interest. If mistakes slip through, they're the ones who will have to face the music in court. The hearing officer, will come to that. And the advisory committee I've mentioned is the forum in which the member state authorities come together and discuss a draft commission decision. The hearing officer now. The hearing officer developed as a role in the early 1980s when you had complaints by certain undertakings in certain cases that they were unhappy with the fact that that you had a case team opposite them who seemed dead set on fining them, and the hearing officer grew from that in the 1982 or thereabouts. The current rules are set out in a commission, or in a decision of the president of the commission from 2011, shorthand referred to as the hearing officer's terms of reference. And essentially the hearing officer's role is to safeguard the effective exercise of procedural rights. Effective can be read in both ways. It means that you make the rights real, but also you don't necessarily, you don't read them formalistically and out of context. It's the hearing officer also has to bear in mind the proper progress of proceedings. So the hearing officer has a direct role, the role of an independent referee or arbiter between DG competition and the undertakings that are either the targets of the statement of objections or third parties or interested third persons. And the hearing officer has a reporting role and a kind of advisory role, in particular for procedural matters, but not only procedural matters. The hearing officer can comment on anything. I'll go back up a little bit, and so the direct role involves organizing oral hearings. These are presided over by the hearing officer. They are not open to the wider public. The members of the national competition authorities can attend and can ask questions. And the way things happen is that the undertakings who are the target of proceedings, they have received their statement of objections and they have asked for an oral hearing in their written response already. And they develop their arguments in defense orally in this hearing. And the commission services are there very much in listening mode and not in combative mode. They ask questions to elucidate their understanding of the case. But if, for example, you get maybe certain officials who get enthusiastic and start even making faces that express disagreement with what is being argued, then the hearing officer will deal with that and step in. And often the hearing officer will explain to case teams that this is the way a hearing will work. It's commission listening to the parties and not arguing a case with them, a case that they're subsequently going to decide themselves. And it's very important that the member state authorities are there as well, because that gives them a good insight into the case, so that when they appear later on in the advisory committee, they'll be familiar with not only the commission's version of things, but the defense that has been put forward in person in the hearing. The other direct role that the hearing officer has is in connection with admitting applications to be interested third persons. So those are from companies usually, or organizations that are not themselves part of the proceedings, but who demonstrate a sufficient interest in the outcome of the proceedings to be given a certain limited level of rights to be heard. And that limited level is to be told about the nature and subject matter of the proceedings, and to be given the opportunity to comment in writing on that. And if appropriate, but not automatically, only if appropriate, they may be invited to take part in the oral hearing as well. So as the hearing officer, when he or she is acting as the referee between undertakings and DG competition, that can be through formal decisions, like, for example, decisions extending the time period in which to make a submission, or deciding on the level of disclosure that needs to be made to the party in the context of access to file, or the level of detail in a final published decision, for example, that could have a big bearing on the nitty-gritty details that would be damage claimants might want to use in follow-on actions. There's also less formal, so there's a finite set of situations in which the hearing officer can take a decision as a referee, but actually the hearing officer can take on that referee role in terms of anything that comes to him or her once it has already been attempted to sort it out at the level of DG competition. All of these things have to go to DG competition first, and it's only if the matter can't be resolved can the party go to the hearing officer. If a complaint comes to the hearing officer and they haven't argued it out with DG competition and hit a wall, the hearing officer will simply say, well, go to DG competition. And in the majority of cases, things are settled at the DG competition level. But for matters that the hearing officer doesn't have express decision-making powers, he can still, or she can, still have an influence on that, because de facto, the hearing officer has this reporting role, and the reports come on the inside of the commission after an oral hearing, if there is one, and to the wider public at the end of a case. And the hearing officer can write about anything he or she considers relevant in the report. And that, in practice, creates a good amount of leverage. If the hearing officer doesn't have a decision-making power, implicit always is the fact that he or she can write about disagreement with some kind of procedural matter in a report. And so the commission, DG competition and the commission more widely, won't want to see a hearing officer's report coming out and saying there is a procedural problem here. So in practice, even if the hearing officer doesn't make a decision, if the hearing officer indicates that this needs to be sorted out, DG competition will typically find a way. And so I've mentioned the reporting. It's internal, an interim report sort of after the oral hearing, and then externally. That's the final report that you will see published alongside a final decision in the official journal and on the Commission's website. And it's in the context of reporting that the hearing officer has a kind of advisory role in specific cases, but also as regards matters of more cross-cutting general interest, let's say. And as I said, like the legal service, the hearing officer being there means that a lot of stuff that would otherwise be banana skin for the commission in court never gets as far as court. And you've had some big cases which are argued entirely on substance, not on the procedure, even if in the procedure they've been fighting tooth and nail with DG competition on procedural questions. But because the hearing officer has dealt with them and the legal answers are there in the final report, possibly they feel that they're not going to persuade a court that the procedural issues are still a problem by the time the commission decision is adopted. Just looking at the time.
Can I ask something about the hearing? Is here in Zoom, Beatrice. So how often the hearing sessions occur? Because it's really different from Brazil, that is where I have experience with. And is it more common like in mergers or in conduct investigations such as cartels? And maybe the second question would be on the third parties. Is it common that they request access not only to the hearing itself, but to the case files or to contribute? Because even comparing to Brazil, there is a big difference in merger and cartel cases. normally they tend not to accept the intervention of third parties in a cartel investigation, but in mergers, they more likely accept. So I just wanted to understand a little bit.
Yes, yeah, very good questions, and thank you. You're right. There is a distinction in practice between antitrust, which is what we're focusing on in this module, and merger control. But also in merger control, there is the right to an oral hearing. As you probably know, in merger control, there's a two-phase procedure, potentially, but most cases are dealt with in the first phase. It's only when you get to the second phase that there is a statement of objections, which triggers the right to an oral hearing. And in merger control, I don't know if it's still the case, but when I used to be more closely involved in these hearings, not always did the parties use their right to ask for an oral hearing. In fact, it was more the exception that they did, because there is a tight, fixed time frame in which to adopt a decision in merger proceedings. And if you're in a second phase case and you want to get your deal through, and the commission has gone to the stage of seeing fit to send a statement of objections, often advisors see it as time better spent discussing remedies with the commission that would allow them to clear the transaction with commitments, rather than by fighting with them in an oral hearing and having the clock still ticking, leaving very little time for remedy discussions afterwards. That, I think, was the typical situation, but there have been situations where you've had both oral hearings and successful remedies discussions. Sometimes you'll have oral hearings after which the parties to a concentration will decide that rather than see it being prohibited, they'll pull the notification, and so there won't be any decision that will be in the public domain with the relevant market definitions and so on that may be inconvenient for them afterwards. And another thing about merger control and oral hearings is that if parties really dig in and ask for extensive access to file, that can create quite significant challenges for the commission and for third-party information providers, because a lot of the time third-party information providers who would have been asked for information in the context of the commission's investigation would have provided that information, but subject to quite extensive confidentiality claims. And if a merging party is seeking to go beyond those confidentiality claims, that's something that can be accommodated if necessary by going to the hearing officer. But when that's being done in the timetable of a second phase merger investigation, that's pretty heavy stuff for all concerned. On the antitrust side, in terms of the participation of interested third persons, well, firstly, it's only if appropriate that any requests would be for them to participate in an oral hearing would be accepted. It's not a given right for them, and if they have to apply separately for participation in an oral hearing. When they are admitted as an interested third person because they've shown a sufficient interest, they get this description of the nature and subject matter of the proceedings, and they have the opportunity to make comments in writing. And it's in those comments that they would ask to take part in a hearing if one is organized. They can't ask for an oral hearing. That is the right of the addressees of the statement of objections alone. But if one is organized and if it's appropriate, the interested third persons will take part. What one can sometimes see is that if you have a situation, and I think we'll come to it, if you have a lot of interested third persons or another variety of third persons, which is complainants in a case, the addressee of a statement of objections may choose not to have an oral hearing in order to avoid having a long, long list of third persons taking the floor. They have less time, obviously, to make their submissions than the main party. But if the feeling is that you will have a long string of third persons saying how awful the conduct is, then maybe it's better not to have the oral hearing at all. Has that answered your two questions?
Yes, thank you.
Okay, and thank you for the questions. Judicial review, so that's a review of legality before the general court in the first instance. When you have the general court is the lower tier court in the Court of Justice of the European Union, the higher tier being the Court of Justice itself. And it's that higher tier which issues these rulings on references to it for interpretation of EU law from national courts. But if you're challenging an administrative decision, it's a two-tier thing, and you go firstly to the general court, and you can challenge a commission decision on 4 grounds that really encompass a lot, and they're in Article 263 of the Treaty on the Functioning of the European Union. The main one is a misapplication of the treaty rules or any rules for the application of the treaty rules. So a substantive mistake of European law. There's also a ground of misuse of powers, of a failure to respect essential procedural requirements, and a lack of competence. But as I think I mentioned in connection with the Amazon decision, not all legal acts of the Commission can be challenged straight away. One example is a decision opening proceedings. That is considered, since the famous IBM case in the early 80s, as being a preliminary act which doesn't change the legal position of the addressee to the extent that it gives them standing to go before the court. And the legal interest to challenge something has to continue right until the end of proceedings. If it doesn't, then there will be, then the reason for the general court to give its ruling will fall away. It's not easy to have legal standing before the general court if you're not the addressee of a legal decision, but that will be typically the case for example, cartelists who've been issued fines. They'll be mentioned in the decision, so their legal standing will be quite clear. And the general court, thanks to the treaty read in combination with Article 31 of Regulation 1, has unlimited jurisdiction regarding fines. So review of legality is limited to the heads of claim that I mentioned earlier, which are wide, but it doesn't mean that the general court checks everything from scratch. It doesn't go into the shoes of the administration and look at everything from the beginning. It reviews legality alone. But that's not the case for fines. In the case of fines, the general court can go in and within certain limits adjust the fines if arguments to that effect have been made and are persuasive. It doesn't mean that the general court, just for the sake of it, tinkers with the fines, but it can adjust the fines. In doing that, it has to be careful, of course, that it doesn't go outside of that remit and make factual findings that weren't in the administrative decision in order to justify a different amount of the fine. And there's case law setting aside a general court ruling for that reason. Then, once there is a general court ruling, there is the possibility to appeal to the Court of Justice. But an appeal is on points of law only. So the facts are not re-argued again. In practice, the clever lawyers will seek to cloak arguments that may, in less able hands, touch too much on the facts. It's often possible to make a legal argument out of something. But if that is patently and transparently, in reality, an attempt to re-argue the facts, that will be rejected as inadmissible. If the Court of Justice finds there to be a legal problem justifying the setting aside in full or in part of the general court ruling, it can, if the state of the file permits, deal with the action as it stood before the general court itself. But if the state of the file doesn't permit that, if, for example, not all the facts have been clearly found and so on, then it's not in a position to decide the main application itself, and it has to remit back to the general court the case to hear again, in practice with a different composition. And to take a well-known case in which that happens, you just need to mention Intel, which I think we'll mention later as well. Also, in practice, it's very important to remember the possibility of interim relief. And often one sees lawyers focusing on Article 278 TFEU, which concerns the suspension of the Commission's decision, pending an appeal or whatever. And that is useful, but people tend to overlook Article 279, which allows interim relief for any other reason. And for example, in publication cases, that's something that is perhaps underused by advisors who would seek to prevent the publication of certain things. I'm not saying that they'd be successful, but I've had the feeling in the past that people read only as far as 278 and not the article following it. And I think we'll take a break there because the next part is an appetizer for what Constantine next Friday will go into in more detail. And I suggest we break until 10 to 5, so 4:50.
Hey everyone, are you back online? We will start the last hour.
Okay. Now we're into possibly what is the kernel of the whole module, the Commission's proceedings. We'll be focusing on the Commission from now on, and I have a feeling that Constantine next week at least will be focusing on competition procedures. Some of what I'll touch on now, Constantine will go into more detail on. What I plan to focus on is the standard procedure in a sample case that we assume goes all the way to final decision and beyond. You'll see that there is the standard procedure in Commission cases that will lead to an infringement decision under Article 7, but there are three main alternative procedures. There are others, and Constantine will mention those too. And the others are of more recent provenance in EU competition law practice than the standard proceedings, and they are more consensual. And some people say that the rise in these consensual type procedures means that there is a shortage of hard legal precedents that actually clarify the law for actors outside of the parties to the case. I'll mention firstly, once I get my clicker going, Commission. First of all, can I ask, can the people at home hear me? Because I see on this screen that it's telling me I'm muted. Can you hear me at home? How do I get a start?
Yes, they can.
Good. Thank you, Valerie. Yes, this is too small to see properly on a slide, but I'm putting it there to let you know that there is this quite useful flowchart at the back of a Commission soft law notice on best practices in antitrust procedures, which is a very useful read if you haven't read it already. And I already mentioned, for example, that it's here that the Commission mentions state of play meetings and nowhere else. It's not bang up to date in some respects, and I'll mention one important respect it's not up to date. You also have on the Commission's website very detailed manual of procedure that the Commission last made public in 2019. And you have different modules in that, which shows you the kind of procedure that Commission officials will themselves be carrying out in different given situations. And the reference in the EU's official journal for this best practice notice is what you can see there. There are two stages in a Commission administrative competition procedure. The preliminary investigative stage is the first one. Some people call the second one the inter-parties or the between parties phase, but I personally avoid that phrase because it tends to suggest that there's no room for investigation in the second phase, when actually circumstances can arise where the Commission carries out further investigative fact-finding procedures. So I simply say that it moves to the moves out of the preliminary phase into the second phase, and it's in the second phase that the rights of the defense kick in full. And those rights include, in particular, the right to be heard through the issuance of a statement of objections, the right to reply to that in writing, and to request to develop one's arguments orally in an oral hearing, if one chooses. But there are the kind of things I'll cover now in the next few minutes are the sources of cases, what happens in the initial phases when the Commission has to decide whether or not it will take a case forward. I look at some of the investigative instruments available to the Commission, and Constantine will go into further detail, I think, on that next week, but I don't want to put him on the hook for that. And talking about opening of proceedings, we've already mentioned it before. If the Commission opens proceedings, it means that national competition authorities can't open their own proceedings or have to suspend any proceedings they have open. That is, unless the Commission carves out your particular member state from its opening of proceedings. And at around that stage, or shortly before or after, the Commission will take a position on how to proceed. That could be via commitments or one of the other alternative procedures that we'll get to at the end, or it could be to go for a full-blown infringement and fining decision under the standard procedure. That's not a position that's fixed in stone. Things can change, and the Commission's preferred course of action can change as circumstances change. So, sources of cases. Can anyone tell me a couple of ways the case can come to the Commission? Nobody wants to? Yes, that's what I have as number one as well. You'll see the diagram there, the old prisoner's dilemma. Design, well, it has applications in many walks of life, but in the cartel world, the theory goes that if the payoffs and the costs are aligned in a certain way, it will mean that the cartel is unstable. And if you can move the dials a little bit enough to affect the payoffs beyond what they are naturally in a cartel, because even if there isn't a leniency program, the temptation will be there to deviate from the cartel rules. But if you make the rewards for deviating and the costs of not deviating greater, then you will have more and more leniency applications. And for a number of years, the Commission had a very steady diet of cartel cases on the basis of its leniency programs. I was discussing at the break with some of you that is not necessarily the case these days, due in part, so the prevailing wisdom goes, to the increased risk for cartelists of seeing very substantial damages flowing from all sorts of private damages claims. Another source of complaints, or another source of cases, is complaints. Formal or informal, they can be from companies or simply concerned citizens. A kind of subcategory of complaints are whistleblowers. And the Commission has indeed a whistleblowers tool, which increases the confidentiality of information transferred to the Commission in a way as a means of offering greater protection to people who blow the whistle on maybe their own employer. I heard somebody saying earlier today that it could be competitors blowing the whistle on other competitors, conceivably, but the tool is there in order to get information on potential cases. And it's very important, of course, to protect whistleblowers. There is an old case in the reports about a certain Stanley Adams, and it's a particularly sad human story from back in the which cartel was it? The Visimins cartel. Sorry, I shouldn't be specific about individual companies, but it was a Visimins cartel, and this employee disclosed confidential information, or disclosed incriminating information to the commission that allowed the case to be brought, but through inadvertence, the companies were able to work out who it was. And this gentleman, because of the way the rules in Switzerland were set up at the time, found himself at the sharp end of the Swiss legal system in jail. And that's only the half of it. It's kind of a sobering story, and hopefully something that would not happen today. Another way a case can come, or a potential case can come to the attention of the Commission, is through its own observation of markets. One hears stories of the good old days when officials used to read the financial press and try to discern anti-competitive practices there. I doubt if that ever actually did happen. People are certainly too busy to be reading the paper for work too much these days, but there is an element of trying to detect cartel activity in particular from quantitative observations in the market. And there have been cases concerning requests for information, and maybe I'll talk about them when I get to requests for information. These are traffic lights, go, no go, let's say. And so whatever way a case comes to the Commission, you'll have at all stages throughout the proceedings, the ongoing calculus of whether this is a case worth proceeding with or not. Many cases at the very beginning will not be cases worth pursuing. And it's a question of resources, among other things. So the Commission will tend to pursue those cases which are clearer and stronger and have a better prospect of leading to an actual finding of an infringement or something similar, or which are important from a systemic level for the development of competition policy and so on, or which have really bigger economic impacts than other cases. And complaints don't always lead to proceedings being opened. Constantine will talk, I believe, about the procedure for rejecting complaints, but just bear in mind that this go, no go decision exists not only at the initial resource allocation stage, but at later stages also. Now we're moving on to the tools, the investigatory tools that the Commission has in its arsenal. And the first one is requests for information, written requests. They can be informal requests or requests by decision. The big difference between those two is that the requests for information adopted by decision require an answer. Excuse me. Whereas the addressee of an informal request is not obliged to answer. in the past, it was claimed that the Commission had to go through the phases and ask first informally and then only proceed to a decision, but that's not at all the case. I mentioned a couple of minutes ago the fact that in an effort to detect anti-competitive behavior, the Commission has on occasion used requests for information to observe a market and confirm suspicions of anti-competitive collusion, for example. The big example there is a series of cases in the cement sector, which we've seen cartel behavior in the past, but as part of possibly this more economic approach, one gets the feeling that the Commission sent big requests for information in great detail and volume in an effort to use quantitative econometric techniques to give to confirm or disprove possible cartelistic behavior. But those requests for information were challenged and successfully challenged in the general court, and so it's something that happens less now. The saying goes that they have to be focused, and so-called fishing expeditions are not allowed. So there has to be some basis for a suspicion of anti-competitive behavior, and this has to feature in the request for information so that addressees have a chance to challenge it. And there are fines and penalty payments available for failure to respond to requests for information adopted by decision, or to respond on time to those kind of requests. Since informal requests are not obligatory for a response, then they don't kick in. But still, if you supply false or misleading information in response to them, there are fines and penalty payments available there too. Inspections, often called dawn raids, but it's actually rare in practice. I think that inspectors call at the crack of dawn, maybe in winter. These are covered in Articles 20 to 22, and Constantine will go into them in more detail. But just to give a little bit of a flavor, the main place of an inspection is business premises. And typically, one is looking for the famous smoking gun kind of evidence. That means evidence which clearly discloses that anti-competitive behavior is taking place. They don't often happen at dawn. And when Regulation 1 was being drawn up, it was based on Regulation 17. And certainly when Regulation 17 was about, there wasn't the same level of computerized storage of information as there is now. And even compared to 2002, when Regulation 1 was being adopted, the level of information stored on the cloud, for example, I mean, the cloud wasn't a thing back then, but the case law accepts that a search of a business premises means also that you can search on information through information stored in the cloud. Again, not fishing expeditions. The national competition authorities can be involved as well. They often accompany officials from the Commission on dawn raids, on these inspections, possibly because of their familiarity with local rules and local conditions. A national competition authority can request under the ECN Plus directive another to conduct inspections on its behalf. and the Commission can request a national authority to conduct an inspection on its behalf. That's something that's quite rare in practice. It may happen, I don't know, where the Commission doesn't have sufficient linguistic, enough people who speak the right language, let's say. But I think the Commission will typically always have somebody there along with a member state national competition authority representative. If there is the perceived risk of argy-bargy kind of opposition to an inspection, the police authorities can be called upon to assist. And there's also the possibility in specific circumstances of searching not only business premises, but private homes and motor vehicles. I'll give you an example of private homes. It's when there is a bitumen cartel. I think it came not with the Commission, but in the Dutch Competition Authority. And what I've heard is that there was a divorce, and the ex-son-in-law knew that his former father-in-law had cartel evidence stowed away in the attic. And it must have been an acrimonious divorce, because the husband called in the authorities and knew exactly where to point. If one didn't have the legal possibility to search private residences, that cartel evidence would have been off limits. But it just goes to show, if you have cartel evidence, don't tell everyone you have it in the attic. Yeah, that's it, I think, for inspections for this week. Interviews is another example. And I mentioned earlier that in one notable respect, the powers of national competition authorities go further than the Commission's powers. And this is the example. Interviews is something I understand that was based on a possibility under Irish law initially, when Regulation 1 was being drawn up. And it allows the Commission to interview, for example, executives and employees of the company concerned. But the big thing for the Commission is that there isn't a compulsion on the interviewee to take part at all. So it's a voluntary thing. And in the Intel case that I mentioned earlier, not only is that an important case for abuse law, Article 102, it also led to a change in the Commission's practice that is not reflected in the notice on best practices that I mentioned earlier. What happened in Intel is that an adequate record of the interview wasn't made, and the Commission sought to defend this by making a distinction between so-called formal interviews and informal interviews, and the court was not convinced and found fault with the way that the Commission conducted an interview with an executive from one of the let's say, complainant companies involved without making a proper record of it that Intel could examine and make a defense on. And yes, that's the ECN Plus directive, probably influenced by the fact that the Commission doesn't have this power of compulsion, because that's what it gives to member states as part of this plus element. Now, there are two limits to the Commission's powers of coercive fact-finding. One is legal professional privilege. It's something that exists in many legal systems, but the rules on legal professional privilege in the EU are not quite as extensive as they are certainly in common law jurisdictions. Notably, they don't cover in-house counsel. And that is something that has been challenged on more than one occasion, but the court has held firm and said that there is no legal privilege attaching to communications between in-house lawyers and their colleagues in the same company. The privilege, of course, is not something that, despite its name, attaches to the lawyers, it attaches to the client, and it's something that the client can waive if it sees it as being in its interests. And there are, to date, 3 main categories of types of legal privilege in EU law. The main one being from the AMNS case, and that is communications specifically drawn up for the purposes of the company's defense. The second 2 categories are kind of subsidiary to that. The other one being AXO, communications that simply relay this advice. And the third category being HILTI, material that is drawn up specifically for the purposes of obtaining this kind of AMNS legal advice. And because it's something that the Commission should, if things work out the way they're supposed to, not see at all. It's not that they can read something, find it privileged, and then give it back. You have a so-called closed envelope procedure, which goes back to an early case, a different AXO case, which was a ruling that happened again at a time when you didn't have vast amounts of information stored either in the businesses or in the cloud. It seems to be designed for, like you see in the picture there, individual documents that can be the subject of arguments. But what one sees in practice now are legal, disputes between undertakings who claim that all sorts of things are potentially legally privileged. It's kind of needle in a haystack stuff, given that inspectors for the Commission or national authorities are nowadays generally conducting their searches not in filing cabinets, but using powerful forensic software to sift through all the electronic records of the company. And so they're not reading everything, and the idea of having a cursory look doesn't necessarily translate well into the forensic information technology environment where you have keyword searches and so on. So while it's a kind of a rare occurrence, this is a possibility for disagreement in practice. And what you have nowadays to kind of formalize the so-called AXO procedure is a possibility to go to the hearing officer claiming that a certain thing is legally privileged. And because the hearing officer is separate from DG Competition, a condition for having the hearing officer decide on your dispute with the case team is to allow the hearing officer actually look at the material and decide whether it's legally privileged. And in practice, the fact that the hearing officer may look at something and feel that it's not legally privileged means that companies will only really come to the hearing officer when they're quite confident that that will happen. But it can also happen that we're talking about such a volume of information that the companies themselves only have a vague idea of whether something is plausibly privileged or not. And the hearing officer doesn't make a decision in those circumstances, but adopts a recommendation. And it's the commission itself that makes a decision one way or the other on the basis of the hearing officer's recommendation. And it's at the end of proceedings that can be challenged, the commission takes a decision, and it's that decision, not the hearing officer's recommendation, that can be challenged in Luxembourg. The second limit on the commission's powers of coercion in finding information is the privilege against self-incrimination. And that stems from the fact that it's the commission as the investigator that bears the burden of proof, or the commission as the decision-making authority, rather, that bears the burden of proof. And that means that the commission isn't allowed to ask questions of the nature, are you guilty of an infringement of Article 101? Because that compels the addressee of the question to say, conceivably, yes, I am. But that's something for the commission to prove. So those kind of questions are off limits. But what aren't off limits are factual questions, like, did you participate in this meeting? Or please provide this and this document, or all documents fitting this description from date X to date Y. And the seminal case on that is Orcam, and that was recently confirmed in a Qualcomm case of not so long ago. Interim measures I mention here because it's recently become part of the enforcement landscape again, since the Broadcom interim measures decision of a couple of years ago. Before that, the Commission actually hadn't used its powers for adopting interim measures under Regulation 1 at all. It was a power that initially came through case law on the old Regulation 17. And there were cases, but that line of cases came to a kind of abrupt halt when the Commission had a setback in the IMS case. And in hindsight, for the Commission, it was probably a case that was not well suited to interim measures, because it required the addressee to provide something that was alleged to be a kind of essential facility at the time, despite the fact that under German national law, it had intellectual property rights to that and so on. So it was very much using, in an interim measures situation, competition rules as a sword to provide, to require something, so, the addressee to do something actively, and that was probably not the right kind of case. In contrast, in Broadcom, the interim measures simply required Broadcom to stop enforcing certain types of clauses in its agreement that under the traditional case law at least would be kind of considered to be as a matter of form abusive. And Broadcom didn't really contest that on the basis of Intel, for example, but matters proceeded to interim measures and then ultimately commitments. But Constantine will probably talk more about that. What I want to focus on a bit now is the standard investigative or the standard procedure in cases where the Commission sends a statement of objections and we go to a full-fledged infringement decision. And the little scroll at the end represents this decision. And there are various milestones on the way that start with the case moving into the post-investigative phase with the sending of a statement of objections. And I said earlier that the statement of objections is really the foundation for the exercise of the right to be heard in full. The statement of objections explains what the Commission's suspicions are and sets out the case for proceeding to a final decision. If the Commission doesn't include a legal objection in that statement of objections, but ultimately comes to this phase and slips one in, the decision will be annulled because the right to be heard hasn't been respected. And the first way in which the right to be heard is safeguarded is through the written response to the statement of objections. But in order to be able to draw up your written response, you need access to the file. And we'll come to the details of access to the file shortly. And in the written response, I've said before, that's when the addressee of the statement of objections can exercise or not the right to ask for an oral hearing. And the oral hearing, non-adversarial, as I said, and the hearing officer issues an interim report after that. The interim report doesn't go to the public, it goes to an internal audience in the Commission. And for that reason, often gets into the nitty-gritty of the hearing officer's view of primarily the procedure in the case, but it can be that the hearing officer goes into the substance as well. There is the possibility for the hearing officer at any time in proceedings, even if there isn't a hearing, to issue a different kind of a report on a different legal basis that can cover anything, including the substance. And by that stage, the undertakings concerned, which is the term for the addressees of the statement of objections, will have made their defense. And it can very well be that their defense is a strong one. And remember what I said about the traffic lights, go, no go. They are kind of always there in the background. And it's possible that the Commission drops its case entirely at that after hearing the defense. And it does happen. You may wonder why it doesn't happen, for example, in around 50% of cases. But if you go back to the earlier phase where it's a matter of allocating resources and only cases that are in some way important or strong get carried on, then you understand why the majority of cases, I mean, it's not a 50-50 split at this stage. What can happen if the defense is strong that the Commission refines its case, might realize that in fact it has overlooked an objection that ought to have been made in the statement of objections. And in that situation, if it wants to proceed to a decision, it has to issue a supplementary statement of objections. That supplementary statement of objections is exactly the same in its legal nature as a first statement of objections. It means that it triggers, again, a right to an oral hearing, whether or not one has been asked on the first occasion. But if the additional material that the Commission wants to be able to rely on in a final decision doesn't amount to the addition of an objection in the legal sense, but simply concerns additional evidence, let's say, in support of objections that have already been included in the statement of objections, then the Commission has to bring this to the attention of the undertakings concerned and allow them to be heard on it by way of sending them under cover of a so-called letter of facts. And the key difference between a letter of facts and a statement of objections is that the letter of facts doesn't bring with it the right to an oral hearing. The parties can reply in writing, and typically that's it. They may have state of play meetings and so on, but there is no right to a new oral hearing. And sometimes the dividing line between what should be a letter of facts and what should be a supplementary statement of objections is difficult to draw. And if the Commission doesn't get it right, it's challenged in court afterwards. The court says, no, that should have been in a supplementary statement of objections. You haven't respected the right to be heard sufficiently, and the relevant parts are unlawful. But the next phase of the procedure after the parties have been heard on the letter of facts and or another statement of objections is that the Commission, again, will either drop the case at that stage, or if it proceeds, it drafts the decision and it consults on that draft, both within the Commission. The other services are concerned, chiefly the legal service, and they will have input on the content and often the precise wording of the final decision. And you also have the involvement of the advisory committee, which I said is the forum in which the member state national authorities are represented, and they will have had the opportunity to be at the hearing if they so choose. In the pre-COVID days, not all member states typically sent somebody for a hearing, but already before COVID, this kind of secure hybrid format was becoming more and more common. The technology wasn't as superb on occasion, but I imagine that now after COVID, it's quite common that member states probably have something like an arrangement, a bit like we have here, but maybe with fully secure connections, so that member state officials can take part in a hearing remotely. Access to the file. So remember, this happens after a statement of objections is issued. And it concerns, in the first place, the file as it exists at the moment of sending the statement of objections. That's the part of the investigation file to which the addressees have access. But they don't have access to absolutely everything in there. They don't have access to confidential material. They do have the right, however, to a version of confidential material that allows them to understand the content and the implications of that confidential material. So you'll have redacted versions, sometimes of that kind of nature. These might be materials that, especially in an Article 102 case, come from third parties, many of whom may have concerns about retaliation from the allegedly dominant company, and who in practice may redact all sorts of stuff that objectively may not be confidential. And it's the case team's job in the first place to push back on this kind of excessively broad claims of confidentiality. And that's what they do. But sometimes you have situations where when a company receives access to the file, they say, no, we're not convinced that this stuff behind the black is actually all confidential. And we'll go and they challenge that with, in the first place, DG Competition. And again, DG Competition will typically burrow down a bit further and go back to the information providers and say, actually, maybe all of this is not objectively confidential. Can you give us a less redacted version, please? But if that can't be resolved at the DG Competition level, the parties, the undertakings concerned are entitled to go to the hearing officer. And it's one of the things for which the hearing officer has decision-making powers. And so the hearing officer can order a greater level of disclosure. And that's something that the information provider can challenge in court. So in practice, it's something that doesn't usually go to that lengths. And on the other hand, if the hearing officer, having looked at the material, confirms that it is confidential, and the test for that comes from the case law, it's not publicly known only to a limited number of individuals, and it, if disclosed, would cause harm either to the provider or to third persons. And if that's the case, the hearing officer, by decision, will reject the request for greater disclosure. And that decision is something that is considered, like the opening of proceedings, to be an interim step in proceedings, and it can only be challenged at the end, along with the final decision represented by the scroll there. It's not something that can be challenged in the middle of proceedings. The CD-ROM there denotes the fact that access is not given anymore in cardboard boxes filled with documents, because the volumes are simply such that it's all stored on some kind of electronic storage device. And for some types of information, it's not always possible to give non-confidential versions by simply blacking out some bits, and yet it's sufficiently relevant that the parties concerned have to have some kind of access to it. So alternative ways of giving access to this kind of important yet genuinely confidential information are data room procedures, which many of you are no doubt familiar with, possibly not in competition law settings, but in commercial law settings. That means that as a small circle of advisors of the undertaking concerned go to the premises of the commission and examine for themselves as advisors, lawyers, economists, or whatever, and they can read the confidential stuff, but the actual client and the employees of the client are not allowed read it. And the fact that it's in a literal room in the commission's premises for a limited period of time, and they can only take out a report of that's vetted by DG Competition, ensures that the risk of them being able to divulge stuff, if they were so minded to do, because they're not professionally permitted to do that. That's quite a protective way of access to certain kinds of information. A variant of that doesn't involve the room, but it's access more remotely to a limited circle of advisors who sign up confidentiality undertakings, saying that they'll have a look at it, but they won't transfer the confidential bits onto their clients. They'll report on it in a way that preserves the confidentiality. And those are two mechanisms that can be ordered by the hearing officer or that are part of a more consensual solution arrived at either at the DG competition stage or at the stage of the hearing officer. Then third parties in commission proceedings, some of it we've touched on already. A key point is that the level of procedural rights that they have, whether they're complainants or interested third parties or addressees of requests for information, etc., they're not of the same extent as addressees of the statement of objections. Complainants have a kind of a right to access to documents, but it's not comparable to the right of addressees of statement of objections. Importantly, it just doesn't cover confidential information. So a complainant won't be getting this kind of data room or confidentiality ring treatment. Yes, I already mentioned the interested third persons and their more limited rights of being heard. They can participate at hearings. And I mentioned, without naming the case, Google Shopping. It ended up being an infringement case, as many of you will know, but it at one stage was on a commitments track. We'll come to that. Notably, in commitments, you don't have a finding of infringement. But Google Shopping was a case where you had a high level of third-party involvement. You had something like 40 complainants and a high number of interested third persons. And I mean, it's my personal opinion and I'm speculating, but they didn't have a hearing in Google Shopping for whatever reasons. But I mention it here also in connection with the final point there, the market testing of proposed commitments. The fact that Google Shopping was at one stage on a commitments track, but then switched back into the standard procedure track is not any sign of things having gone wrong. Rather, it's a sign of the system working as it was designed. The commitments were offered by Google. They were, as they called it, market tested. That means they were published in a non-confidential form, and third persons and the general public had an opportunity to comment on them. And the reaction against these commitments was such that the Commission reassessed whether commitments were appropriate, and on the basis of that reassessment went back onto the standard procedure track. Time limits and related issues in competition law. Firstly, we have limitation periods. We mentioned them in the national setting earlier this afternoon. As far as the Commission is concerned, it's Articles 25 and 26 of Regulation 1 that come into play. 25 concerns the imposition of penalties, and 26 concerns the enforcement of that. So it's one thing to impose a fine on somebody, it's another thing to go and actually collect it. And the provisions are relatively complicated, but you have 3 years for inspections and requests for information, 5 years in principle for everything else, but they can be interrupted and suspended depending on certain things that can happen, like court challenges, etc. And they're subject to an outside period of double whatever it is. So double your 3-year period or double your 5-year period. That itself being subject to a suspension when proceedings are before the courts in Luxembourg. So it's a little bit complicated, And we discussed a bit of that in one of the breaks earlier this afternoon. In terms of how you calculate time periods, for practitioners, this is a very important thing, because you don't want to be the person who gets it wrong and finds that your case before a court or some kind of procedural deadline is missed in an actual live case. And I've seen actually very eminent people almost get it wrong. And there's a regulation, and I'll put it in the slides, the handout version from 1971, and that still applies. And there is it's worded in a less than clear way, let's say. But for periods expressed in days or months, it boils down to, if it's a day of the week, your deadline will fall on the same day of the week, X number of weeks later. What else should I say? Yes, in a court setting, there's also a case that says it's not for the people who work in the court registry to work out the deadline for you. So you can't be ringing up the court and asking them to work out the time limit for you, or maybe complain that you were misled by suggestions you might have had. It's for litigants themselves to get it right. And it's not quite time limits, but a little tip I would have for people who are signing documents or working with people who are signing documents for the courts in Luxembourg. I would always prefer a color other than black, blue typically, to distinguish the signed version from the photocopies of that, because there was a case, Bell or something, not in competition law, but somebody in the registry did literally a sniff test and didn't smell, but what was presented as being the original proved not to be the original, and the parties said, "Oh, come on, you can't reject it as being admissible for this reason." And the court said, "No, some of these things are bright rules. They're there for a reason. Tough luck." So point of practice would be to use blue pen for the signed version, is what I would take out of it. And then we get to the stage of finalizing and adopting a decision. That's on the assumption that we're in the green traffic light box, and the party's defense hasn't been fully successful. So we will have drafted it and consulted it as I described earlier, with the legal service and so on, and the advisory committee. Ahead of the advisory committee, the hearing officer produces an interim report, and that's for the attention of the advisory committee, not for the public. But the final report that is issued to the public is in practice very close to that draft final report that goes to the advisory committee. Sometimes it can actually change. It's linked to that leverage that I mentioned, whereby the hearing officer may say something in a certain way in the draft final report, and that will be sufficient leverage for something to happen, even at that late stage in proceedings, for maybe something to be dropped from the draft, which wasn't quite procedurally as it should be. And so you can have sometimes differences between the draft and the final draft. Then it goes to if it goes through the advisory committee, it will be adopted by the College of Commissioners. Post-decision publication is something that, especially in the cartel context, can be contentious, because the cartelists don't want to see a huge level of detail in the decision, and that's also something that can be settled, if necessary, at the hearing officer level by decision. Obviously, there can be court challenges in Luxembourg, and we discussed that earlier, and follow-on actions, which we also discussed earlier. And now to finish out a little bit, I'll just touch on some of the alternative proceedings that Konstantin will talk about a little bit in more detail next week. Commitments already we've touched on. A chief or notable feature of that is that there's no finding of an infringement. The undertaking concerned says that it will adopt a certain course of behavior, and it commits to doing that. And the Commission notes this commitment by way of formal decision. So it's more of a yellow card than a red card, let's say. We discussed the situation of Google Shopping switching from commitments back to the standard procedure because the commitments were considered to be inadequate after hearing from third persons. A very well-known commitments case is Microsoft, the internet browser matter. There were commitments made by Microsoft, and subsequently Microsoft didn't adhere to those commitments. And at that stage, the issue was not whether it was a breach of the substantive rules, Article 102. The issue was whether or not Microsoft had breached its commitments. And Microsoft more or less, well, didn't contest it very vigorously, and was hit for a fine, not for abuse of dominant position, but for failure to stick to the commitments it made. Gazorba commitment decisions are not binding on national competition authorities, and Canal Plus, I think I'll leave to Konstantin. Cartel settlement procedure was introduced as a kind of streamlined, more consensual way of dealing with cartel cases. It was introduced by means of changes in 2008 to the Commission's implementing regulation, 773 of 2004. And what happens in brief is that you have a series of meetings with the case team, typically 3 rounds where the Commission shows the information that it had, the evidence that it has, and the 2 sides come to a description of the events, typically much shorter than you would have in a full-blown cartel case, and that's part of the possible attraction of this for cartelists. Another big attraction is the 10% reduction in the fine as it otherwise would be under the standard procedure. And there have been several cases there stemming from the fact that in a cartel you'll have a multiplicity of members, and not all of them will necessarily go for the settlement route, or if they go for it, maybe they don't go the whole length of the settlement. And what happens when one or more pull out of the settlement route? Well, TIMAB is a case that it says, well, for them, things revert to a clean slate and the standard procedure continues, as if, in a way, the cartel settlement discussions had never happened. TIMAB also says that it's okay if you have proceedings, or technically it's a linked stream of proceedings. They're all individual proceedings, but it's a bundle of proceedings. And if that bundle splits out into separate parts, some on the settlement procedure still, some on the standard procedure, so that you have an overall bundle, a hybrid bundle, that's okay. And then the yet more complicated situation is when the Commission decides to adopt a decision on the settlement route before it finishes the standard procedure. And that raises very interesting issues of presumption of innocence and so on. So far, the courts have said that that's possible once sufficient care is taken in the wording of the settlement decision, so as not to prejudge the guilt of the parties who are still in proceedings under the standard route. And finally, we have the non-cartel cooperation procedure, which in many respects takes inspiration from the cartel settlement procedure, but there are a number of differences. One is that it's not actually set down in any regulation. It's a practice that started with the ARA case in 2016, I think. Another difference is that there isn't a fixed percentage reduction. Depending on the facts, it could be, much more than 10%, but not necessarily. And otherwise, it procedurally follows a bit the cartel settlement practice of having typically 3 rounds of meetings, reaching a common understanding on the description of the infringement. And by the way, under both the cartel and non-cartel settlement procedures, you have an finding of an infringement, but you just have a lower fine. Whereas with commitments, you don't have a finding of infringement. So that's a big difference. And now we come to this little guy who's taking a key away, and our key takeaways for this afternoon. So firstly, it's the fact that EU competition in law enforcement is not done by the Commission alone, far from it. National authorities are also involved, and also the courts of the member states, and to the EU courts in Luxembourg. The importance of procedural fairness we've discussed in several aspects, notably the fact that judicial review of Commission decisions means that its integrated agency model doesn't actually fall foul of the right to fair trial for the purposes of Article 6 of the European Convention on Human Rights and the analogous provisions of the European Charter. And then in this last session, we've looked at the stages and main types of Commission proceedings, and that's something that in the next 2 sessions, we'll probably delve into greater detail. So that's all I wanted to say, but if anybody has any questions now, I'm happy to deal with them.
A question that is maybe a bit remotely related. I was recently involved in a proceeding for the German competition agency, and we were hypothetically thinking how would the case be dealt with in front of a European agency. So if I launched a leniency application, or if I launched a filing for a marker to be set on me, and doing the review, I mean, most of the time you simultaneously file for a marker and start the internal investigation to collect evidence for the bonus application. And if I, during that investigation, find out that I may not need a leniency application because I have good arguments to defend the case, could I withdraw the marker application and have the Commission not being allowed to use that information against me?
Yeah, it's an interesting question. And I'd have to deal with it in hypothetical terms. And to be frank, I don't know for sure. I think it's not something that's necessarily covered under the Commission's leniency notice. But I wonder whether in practice, if people have a situation like that, whether it's as simple as saying, oh no, I'll take back the leniency application and I'll argue my case. For me, I imagine that the leniency application could be maintained, and you can, if one believes that one has a strong case of even the absence of liability, then that can be done safe in the knowledge that maybe you've perfected your marker, at least for the purposes of fines. So you have coverage there. But that's a question of tactics. In cartel settlement proceedings, to move away from a specific case a little bit, but there comes a point when it's a point of no return for the settling participant. It comes relatively late in proceedings. It's after the Commission has put a sort of short form statement of objections to the party, and it has the choice of saying, yes, that corresponds to our shared understanding of what happened in the cartel, and I'm not going to question that. Once that happens, you can't pull out of the settlement procedure. And in terms of leniency, and especially in terms of national leniency programs, the candid and I think probably the prudent answer is simply, I mean, I don't know, but there are conceivably, strategic considerations at play that mean that maybe arguments can be made in the framework of a leniency process. Thank you.
Other question?
Oh, yeah. Well, it's 6 o'clock, minute past, in fact. So I won't take it personally if I'm not flooded with questions. I'd like to wish you well for the rest of your course, and thank you for joining us via Zoom, and thanks to the people who joined today, and thanks especially to Valerie and Charles for all the support and organization. So bonne continuation, everyone. And bye to the Zoom people.
Yes, see you next week on Zoom again with Constantine. Have a good weekend. Bye.